Everything will come. Bail matters, all the bail matter will come. Don't worry.
My lord,
Yes.
Relation number 974 of 2017 relates to check bounce case. Stay is there, and at the stage of argument, is not listed.
You are
One
for,
is 91 crore and the other is 96 lakhs.
you are for accused.
No, I am for the, it is complainant.
Next week.
my lord,
Complainant, you are for a complainant.
Yes.
If it is a stage operating.
Stage.
Stage operating. Okay.
my lord, we filed a CRLMA for cancellation of bail granted in favor of the accused.
People are waiting for bail. You are asking for cancellation. What are you talking?
My lord, because after coming from the jail custody, my lord, the accused has been making viral of the naked photographs
Okay.
of the banner.
You give it, we'll cancel it, but wait. Give the memo, sir. It will come in.
Here
Next
is
week,
the
madam. It will come
interim
next
bail.
week.
Your lordship has fixed for 28/2000 for instruction, but inadvertently it is 29/2020.
Interim bail for what?
Mother's illness, he is suffering cancer last stage. That was I have filed a miscase for post
Have you
Abhibaniya.
given the copies?
Already instruction has came out. କହୁଥିଲେ
Positive instruction or what?
positive.
The interesting is he is supposed to get the instruction. He doesn't know.
ଆସି ହେଇଥିଲା ବୋଲି
Then the instruction is managed by you.
It's the last stage.
You have successfully managed the instruction.
No, see, that was the
Same thing to Mr. Raghav. Before you, he has got to receive the instruction.
Last stage, Lada.
That's
Yes, start.
I may be permitted to mention, my lords.
Not tomorrow.
Okay.
Tomorrow.
I may be permitted to mention.
My lord, pardon to mention, my lord.
I may be permitted to mention, my lord.
Yes, let us finish that. Yes, Mr. Anchari.
My lords, day before yesterday, I mentioned a bail application. That is 5616 of 2020.
Bail application, the answer is.
I know, my lords. I am not disputing that. Your lordship has made it clear.
Please have
enough
patience.
that
Please have patience. I think by next week, almost all the matters will be listed. Please.
by
wait.
next week.
It doesn't happen, then tell me. Okay.
Much obliged, my lords. Much obliged.
Yes.
May I pardon to make a mention, my lord.
Yes, madam.
My lord, item number 56 of today's list, my lord.
Yes.
I had mentioned it day before, but my lord, for some unseen situations, I had to travel to Delhi for my mother's checkup. So may it
You
be
want an adjournment. Simply you want an adjournment.
No, my lord, I want may it be taken up at the first
No.
or maybe
No. Wait, we'll see. Yes.
Pardon to mention.
Otherwise, I'll accommodate you for next week. Let it be
My
next
lord,
week.
my lord, but the interim order is in operation.
Okay, it's all right. Next week. Don't get stressed out. Go and attend your mother. We'll do it next
My
week.
lord, my
Next
lord,
week.
but
Next
the
week,
interim order
order.
may be extended.
Yes.
Highly
The
honored.
interim order will be there. You go relax yourself. Yes.
Pardon to
Next.
mention, my lord.
One more is there waiting.
My lord, urgent bail BLAPL 5302 and 5313, sir. So say urgent for
Bail, all bail matters are urgent. It will come next week. Don't worry.
examination, sir. It is urgent, sir.
We'll see. Yes. Bail matters, sir. Every bail matter is urgent, and some urgency is there. And I don't want to allow jumping system. Let it come systematically. So by 1 week we will whatever maybe lady, but petitioner has also committed crime.
Be clear to us.
Wait, within 1 week, if you cooperate, and within 1 week we can adjust
Streamline.
as possible. Please wait.
Pardon to mention, my lord, CRLA number 776 of 2024, fresh admission.
What is the urgency?
Conviction 2 years.
Huh?
My lord, NBW issue already has fresh admission.
Fresh admission.
Yes, ma'am.
Cancellation of NBW.
Yes.
Appeal. Oh, appeal, wait. Appeal, wait. Yes.
Pardon, my lord. Item 7, my lord. No, Mr. Mishra is ill, my lord. The conducting also.
Adjourn.
Let's say item 11. Let's say item.
Seven, adjourn. Yes.
Let's say item 11. I prepare an adjournment. Let's say.
Adjourn. 11 also.
My lord, item 59. Kindly 2 weeks after.
59.
My lord, sir,
My lord,
item,
item
All the
59, your
adjournment
lordship.
will go to October, remember.
My lord, item
46, my lords.
59,
May
your
be
lordship.
pardoned. This side, my lords. Item 46 may be taken
Item
up and tagged in
59,
the
your
weekly
lordship.
list. They
I
have
am for
filed
the
an IF for early
petitioner.
hearing, so it can be
Weekly list, put it in the
item
weekly
46.
list. 46.
Yes,
Weekly list. Okay.
My
great.
lord,
sir.
item 59, your lordship, I am for the petitioner.
Yes.
My learned friend has also requested me yesterday for an adjournment. Your
It's all
lordship,
right, because her mother is not well or something.
no,
Let
no,
her go.
I do not object, your lordship. Only, my lord, the interim order may continue in my favor. That is
Yeah,
there.
yeah, interim order will continue, don't worry. Interim
Bless
order.
you, lord.
Yes.
59.
See, weekly, let it be weekly, but somebody should come. It is mark karo ikra kujya. So that if you want, you can go, no problem. It's a personal difficulty, you must go.
That was mentioning. I was just keeping my cards open for before your lordship. If I can be accommodated. 12. Yeah,
in-
lordship have heard me substantially.
You are enjoying interim order, it seems. So go.
No, it's an appeal matter, my lords. It's an appeal matter. The lordship has heard it in part. It's there in the list.
Let it be there.
Yes, yes, it's there.
Let it continue.
Yes, ma'am.
So that partly I have heard, why to waste that?
Yes, my lords.
Next week, Tuesday, Wednesday, Monday, Tuesday.
Yes,
let
my
it-
lords. So weekly minutes.
Weekly at the top. Weekly at the top you put it, so that you Monday, Tuesday come at by 3 o'clock I'll hear. Miscellaneous work, after miscellaneous work I'll give. Mark it at the top of year.
Yeah, my lord.
12. Okay.
My lord, beg pardon, item 37. 37. He has been acquitted. Permitted to withdraw.
He is acquitted, then you should be happy.
Yes, my lord.
Acquitted, eh? Withdraw.
Then, Lawrence Session Judge reported there.
It's all right.
Uh,
Bail application.
Deposition copy, everything is.
Acquitted with withdraw.
Put a paper.
Yes.
My lord, pardon to mention, my lord, one fresh admission criminal division case. Your lordship has already heard this matter, the MGQ matter regarding and during pendency of this criminal division, the lower court had framed charge against the petitioner. Your lordship has already heard this matter and reserved for judgment. But in the meantime, they framed charge. So technically, this division has been filed. Can be taken up.
I have already heard, and judgment reserve.
Reserved. During continuance of the interim order, they have framed charge against the petitioner.
There was an interim order operating in your favor.
My lord.
Just keep it
On
next-
Friday, Saturday, my lord.
Let it be Sunday.
Saturday रे court अच्छी आ गया.
Vote अच्छी, but
My lord.
presiding officer is not there.
So Monday.
Let it be Monday.
Monday.
ठीक है?
Public.
Because my lord and friend made a mention. Can that matter be taken up today?
Cancer-
Because our
cancer
mother
patient.
is suffering from terminal disease, cancer. So inadvertently, it has been posted to 20th September instead of 20th August. The
But he may not be having that file. You know better than anyone else. You have been changing sides of the file.
No, it's not. No, it is always better to.
Tomorrow may not possible. Let it be on Monday. Let it be Monday.
Diploma.
If he can get the file, then I have no issue. Give it Monday, the top matter, first item called Monday.
Mr. Order, Ragad is too competent. He can get the file within no time.
Monday, item number 1.
My lord, my lord and friend.
Because Monday at the top, huh? Yes.
My lord, item 1.
I don't want to mention.
Why it is listed?
My lord, actually, your lordship wants to have a mechanism to dispose of this old matter, so that didn't work out. Somehow it has come in the, another heading of to be mentioned. It will come in the weekly matters.
Let's say pass over.
That may be tagged in the weekly. So
96.
yes.
See, what I thought is, instead of keeping these matters pending,
My lord.
now we explore all possibility. Nothing is working.
Yes.
So I'll reduce the sentence substantially in the sense 1 week or 2 weeks, because
6 matters.
86, 96 years age people.
Yes, ma'am.
So I'll reduce the sentence to 1 week or 2 week kind of, and we'll dispose it.
Yes, ma'am.
That is a better idea.
Yes, ma'am.
Why to struggle? Conviction maintained,
Yes.
sentence reduced,
Reduced
to
matters.
1 week or whatever,
Yes, ma'am.
with little fine,
Yes.
for 2 days, huh? Otherwise, see, these people are in
Yes.
their 80s.
Yes.
80s
Late-
and
late
yes, some
80s.
people are in 90s.
Late 80s, my lords,
Late
90s.
And the problem is we can't acute.
Yes.
Another problem is
Cannot
we
convict
can't give
also.
provision of offender benefit.
Section 18 is the
Third
bar, my lords.
TRP we tried, that is also
That is not
possible.
working out.
So what to do? The only thing is 1 week or
Yes, ma'am.
something
Yes,
of
ma'am.
that sort.
And section 18
Small,
of
small
PO,
sentence and finish.
section 18 of the PO Act is a direct bar, my lords.
Correct. So therefore, why we can't help it.
My lords.
So it's called judgment trigger.
Let's say pass over.
What passover?
Hmm.
Tell judgment trigger. Yes.
Sir is there. My lords, sir has come.
Here, the short point involved in the present case is some sort of irregularities are committed in the corporation.
Are you aiming at an acquittal?
If
Then we will hear it. If you are not aiming at an acquittal, then I have tried and find out a way. I was telling him.
Yes.
What I'll do is I'll maintain, while maintaining conviction, I'll impose a sentence of about 1 week or 2 days, 3 days, like kind of, and finish it up.
here, other two cases, that order I have
Yes.
accepted that. Here, this usually this father of a lawyer. For that reason, this matter was kept.
Then you are going to argue on merit.
Ballot.
Then list it.
Weekly,
List it for,
weekliness.
weekly at the top. Huh?
Fix up a date. So
Weekly rasio separate.
Fix up a date, get ready then. Prepare a small note.
Small note.
If you are aiming at an acquittal, then.
Because he is bedridden as per their report. Also, I got the information he is completely bedridden, 80 some days. Other two persons and their whereabouts.
No,
not
that I have
known.
already submitted. That has been disposed of because they were all abated. They have they are no more.
Here,
So
he
far
is
as this
relevant
case is-
that too bedridden.
Well, you say that he is the father of a
Lawyer.
Lawyer.
So you.
For
are
that reason,
aiming at-
Malade, yes, I prepared the case. I will prepare a short note also.
So let it be there.
The
Why?
weekly.
Why in supplementary? Why in weekly? Let it be in the supplementary so that sometime you will address and finish.
My
it up.
lords, as your lordship
96
pleases. Yes, ma'am.
this is matter is of 96.
96 months.
You tell me a date so that at 3 o'clock I'll fix and finish it up.
On 4th.
Not next week, sir. Next leave next week will be little.
Not next.
18th.
18th.
18th at 3 o'clock
Yes.
for final disposal.
Great.
What is this matter?
Challenge is rejection of discharge. Here, petitioner is the son of the public servant. Total DA is 38%. In the meantime, the original public servant is died before charge. And while my role is I am son, I was unemployed at the after completion my engineering course and doing some business. So that is how I am tagged in this matter under 109. And curiously, my lord, they have taken
You are 43-year-old.
my lord. But at that relevant point of time when I was tagged, I was not the public servant. I was doing my individual business and paying my income tax and other things. Admittedly.
2012.
2012. Now
What
there
is
are
the stage of
6
the trial now?
discharge has been rejected.
Charge frame है ये जो
Charge frame है
Charge frame must be
Yeah.
discharge was
order of
ସମସ୍ତଙ୍କର ଆଜ୍ଞା ଲୋନ୍ ରିପେମେଣ୍ଟ ଟା ଏକ୍ସପେଣ୍ଡିଚର ରେ ଶୋ କରୁଛନ୍ତି ମୋ
लोन रिपेमेंट ଟା କୋड ଦେଖାଯିବ
but
I'm just saying
at this stage how can I go?
exactly my lord, the honorable apex court say that acquisition ଟା loan ଟା income ରେ ଗଲା ଆପଣ corresponding asset ଟା asset ରେ ଦେଖାଗଲା repayment ରେ ଯେତିକି extra interest ଦିଆ ହଉଛି that is to be, otherwise what is happening, suppose I'm taking a 5 lakh rupees loan for a car, so asset is 5 lakhs rupees for car, 5 lakh rupees is coming to my income, but you can show 6 lakhs rupees as repayment, so then 11 against 5, that is what is
1 lakh rupees.
yeah,
1
has
lakh
to
rupees
be,
to
has
1
to
lakh.
be, That once that is done, I am my case is through. 38% your lordship, 6 persons are employed admittedly, and all repayments.
Towards interest, you might have paid 1 lakh.
Yes, my lord, that's the case. You cannot take all. And here what they have made is that entire family, whosoever, my brother, my sister-in-law, whosoever purchased their car and other thing, all this repayment has been put in expenditure against us. They are not the accused. No charge has been done against them. That 32 lakhs. So once it will be going down to 10.
But it has to be seen the manner of payments also.
Yes, my lord.
When you obtain a loan after 1 month, you paid the full.
No, that's correct, your lordship. That's correct.
Then in that case, you are liable. But where from the source?
No, everything. See, that is not the investigation.
So it has to be seen.
My lord. No. That is not the investigation. They are not saying there is no accusation to that effect. In fact, they have shown 32 lakhs as your loan repayment, where against which I am only paid 17 lakh 60,000. Others are my brother and other persons.
The brothers are also accused.
Not accused. Not accused. And they have taken time to file a written on this only.
Are you ready? Then it needs a...
So far as the petitioner is concerned, jette income tax se kohuchanti, then income tax jette income that has been considered as per income tax return, and assets are found, assets and investment, bank deposits as per till he entering into the public service, 8,68,495 hoci tar income tax re dekhauchanti. Loan paile Indus Land Bank ru JCB Mahindra acquired kariya pai 14 lakh tanga loan nele, किंतु asset किनिले महिंद्रा के पेमेंट कले 17,50,348 टका लोन टा जति कि लोन पाइले इनकम साइड देखाला एवं जोटा asset acquired कले asset साइड देखाला repayment he has made in respect of that is 17,60,000 एतिकी तनु automatically assets income assets plus expenditure minus income automatically it will come down the DA and considering all aspects in respect of the present petitioner ame nei na hu non nei kiri taro 37 lakh
What is the stage now?
Stage charge frame hobo trial hobo
Charge frame hila boli kohtu
nei charge frame se tanko ei godauchanti para 22 masya ru since 4/11/2022
stay operating
no my lord
no
then
na se koithile jo mu seit mai to jane se adjournment application daba pai koithile that thing that order is there then by this time this trial
there is a direct Supreme Court decision on this. My lord, I'm just drawing.
I think sir you
it's
have
all calculation.
I'm just
what I'll do is I'll target the trial.
My lord, I'm just drawing 1 minute to the 75 page.
But these are calculation business.
No, calculation. My lord, what I'm not disputing is 17 lakhs 50,000 is repayment. How it has been considered is a discrepancy. But how can you take 32 lakhs repayment? You yourself in your charge sheet says that I have repaid only.
If 17 is taken, you come down to how?
I will be out.
It come down to 10.
Yes.
Less than 10.
Yes.
No. No, what is 17 or 32? You tell me.
Yes, my lord. 15
if
gone.
You say 17.
17.
You 17 repayment is 17 lakh something.
No, 17 gotiye gadi ro kohuchi. Mu anna gudaye gadi.
Alga gadi guda tar malik ko deychen.
Those vehicles doesn't belong to him or he has.
Na takara jahata seita no kohuchi. Tanko na re achi JCB Mahindra, Bullet, Maruti Zen, Bolero.
He has taken loan for these all these things.
Loan neichanti, loan repayment jati korchan dekhaichi. गाड़ी रो वैल्यू भी देखाइछि लोन टा मध्ये इनकम रे देखा
व्हाट इज दैट
बोलेरो मारुति जेन जेसीबी महिंद्रा बुलेट आउ स्कॉर्पियो जोटा अछि स्कॉर्पियो टा कथा हमें नैनो कारण ता
By the way, what are you doing for living?
My lord, now that time I was engineer. I was
a business
I was hiring. That time I was doing that. Now I am a MBA.
Now MBA period nahi.
I prima facie I am not happy the way.
My lord, that is a direct decision on repayment.
Then I'll hear it. I'll hear it because it's little.
That Supreme.
That is a direct Supreme Court decision on this.
If he is covered by judgment, then it's a different story. But these are all calculation business.
No, my lord, exactly. Exactly on loan repayment and 227.
But at the stage of framing up,
my lord, and 227 loan repayment is the only issue Honorable Apex Court has considered.
Okay, then.
I failed to understand what my
exactly calculation. This is what has been
expenditure.
You have to tell me the law.
My lord, only
charge says, can I go into this calculation business?
My lord,
That is the
only,
that is your
only and only I will impress your lordship on this alone.
Supreme
I
Court.
am not going to,
Supreme
I
Court-
know my limitation, my lord, in the 227 situation.
Nadi, I am afraid that you have a very persuasive capacity. You
No,
can make me to write wrong thing.
The Honorable Apex Court view is that Honorable High Court in exercising 226 or 482 should not do all sorts of chartered
Okay, I
accounts
know,
of
that's,
works.
that's what is troubling.
My lord.
I'll hear.
Well.
I'll put it after a week or so.
I am just giving a copy of this judgment.
Keep it so that
Oh, yes.
I can't read it unnecessary. Yes. 3. Not 3. None appears for the petitioner in the interest of justice. Adjourned. Yes. Yes, sir.
May previous. Petitioner challenges the order dated 27/1/2023. Passing of a cognizance.
Yes.
What happened, madam? Can see the annexation number 3, pledge 12, madam.
Yes.
On 27/1/2023, the London Court below has taken cognizance in a case under section 294 IPC, madam.
Yes.
And the present petitioner applied certified copy on 17/4/2023 after 2 months and 20 days and obtained certified copy, madam. Thereafter, subsequently, the present petitioner came to know that cognizance order has been changed and that is under annexation number 1, madam. Can see the annexation number 1, madam.
What is the cognizance now?
Now cognizance under section 294, 323, 376, 354, 5034 IPC.
The earlier it was only
94, madam.
no. Earlier proceed. Just see, come to annexure 3.
Yes, madam.
It is 294 to 323, 376 all.
Hence, cognizance taken 294 IPC.
Okay. Question, complainant petition to proceed under section 2, hence cognizance. Okay. And thereafter you got the certificate copy.
After 2
Certificate
months
copy?
and 20 days, madam. And then the present petitioner applied a certified copy on 19.
What do you say?
But the notice may be issued since
No,
complaint.
I'll call for a report. I'll
Report
call-
and also the notice to the applicant, madam.
Issue notice to opposite party number 2. On accounts for the petitioner submits that earlier the cognizance by order dated 27/1/2023, the Lieutenant JMFC
Narsinghpur.
Jharsuguda,
Narsinghpur.
had taken cognizance of offence under section 294 IPC while dealing with one CC case number 54 of 2022. The petitioner has obtained the certificate copy. Subsequently, petitioner obtained certificate copy of the same order
On 18/4/2023.
on 18/4/2024.
23, madam.
23. Surprisingly, he discovered that the cognizance order has already has been changed substantially, and in the subsequent certificate in the certificate copy, he found that the cognizance is taken for offence under section 294/326/376/354/506/34 IPC. Hence, he seeks indulgence of this court. Regarding head to the fact that there is an apparent change for the order dated 27/1/2023. A report should be called for from the Land Court of JMFC, Narsinghpur, regarding ICC case number 54 of 2022. Please, the matter. Yes.
Stay up with further proceeding.
Let us see what happened. Let us see next week. Yes.
Complaint case, madam, state not party case.
Yes.
May I please? This case is arises out of a complaint case. In course of proceeding, your lordship, complaint died. Then advocate on behalf of the complainant file a moment that since the complaint has been died, I would not like to proceed with the matter.
Like to?
Proceed over the matter. But the London Court will insisted us for appearance and report has been called from the concerned police station whether the complaint has been died or not. That taken since long continuance, your lordship. no report has been furnished. So I filed this application before the court. According, a report has been called for from the concerned police station. Whether the complaint has been died or not, that has to be satisfied. The law is that if he has been died and would not like to proceed with the matter, then exercising the power 203 of CRP, the complaint has to be dismissed due to non-prosecution. That is taken into by the law and court below.
What happened in this case, I have got instruction, my lord. The complaint expired 2 years, my lord, back, my lord. What happened in this case, my lord? Actually, my lord, whether her family members interested to continue the procedure, that is the question, my lord. And with regards to that, there is no specific provision, my lord. If the complaint died, what will happen in the, that is not there, my lord.
Nay, whether if any family member came forward.
No,
my lord, they have
perhaps
advocate has no.
Perhaps they have not a instructor, my lord. If the summon is issued to the family members, then only they can, my lord.
No, why should we call whether he should do it or not? If they are interested, they'll do it. Why should the court will be a party to ask them whether you want to?
Otherwise, my lord, there is no specific provision, my lord, how the complaint will be.
But this is for sure that a complainant dies, then the family member can do it, whatever. I am not on that.
If they are not,
lawyer can't do it. Lawyer has minimum this thing. Lawyer can't do it.
Implement the family members. But in fact, my lord, two provisions are there, 249 and 256, my lord.
I'll just simply issue notice. You address on that. Issue notice. And
only, my lord, they made the state party. But another
state party and
report has been called for regarding the death of the complainant, lordship. The normally law is, lordship, if it is a case of arises or complaint petition, lordship. Assuming that the complaint has not been died, if she has not been proceeded to the matter, normally it has to be dismissed.
Who is the complainant?
The complainant, lordship, in this case.
Who is the complaint?
Jayanti Malik.
One Jayanti Malik had filed a complaint case, being ICC case number 03 of 2018 against the petitioners. While the petition, what says he that cognizance after cognizance?
After cognizance, process has been issued for our appearance.
After the cognizance of the offence was taken in the said complaint case, the complaint is stated to have expired. Thereafter, report was sought
from the concerned Hon'Ble police station.
From the concerned police station regarding the death of the complaint. The report also confirms this. There is
Jayanti Malik was expired since 2 years back.
The report was placed on record inter alia stating that the complainant Jayanti Malik died since 2 years back. None of the family members, being the LRs of the complainant, came forward to prosecute the complaint. However, it appears that the counsel appearing for the deceased complainant seeks to continue with the prosecution.
No. He filed memo for withdrawal of the complaint.
However, the counsel for the complainant moved an application, moved a memo for withdrawing of the complaint, which has been turned down.
That has not been turned up, your lordship. A report has been called from the concerned police station.
Now what is happening?
That stage is pending, your lordship. A report, awaiting report.
On the memo, again a report was sought for.
Yes.
Again, report sought for, and the complaint is still pending. Complaint case is still pending.
Yes,
at this stage, the petitioner has approached this court seeking quashing of the entire proceeding. Issue notice to the state, written so in the meantime, proceeding before so is still. Yes.
Item 6.
Oblige,
if this order will be sent to the court bill, proceeding pending, it can dispose of.
Dispose of, your lordship.
Your lordship may this
observe that, your lordship.
This objection may be sent to the court bill for consideration that.
So,
dispose of.
Issue notice complaint is pending. I am of the considered view that by apprising these developments, the petitioner should move appropriate application before the trial court if such application is moved, the trial court shall dispose of the same on its merit by taking into consideration the development that has unfolded in the meantime.
And that may be disposable at a time
And
because
the application shall be disposed of within 15 days from the
obligor.
date of filing for the same. Yes, disposed of with this observation.
6.
Let the trial court take the call. You are right, unnecessary. Yes.
Before I take to my lords the impugned order, the facts are like this. I'm the husband. Husband filed a divorce application. During pendency of the divorce, 125 application was filed and 40,000 was awarded, which was confirmed by this honorable court and honorable appellate court, whereas my salary was only 37,000. My lord, I am not digging old graves. My lord, may kindly turn to Annexure 3, page 16.
Now, where is the opposite party number 2?
My lord, in spite of notice, service neither service. Service return has not come, not undelivered notice has come back. It was on the last week.
Awaiting service, no report has been come, whether ID has returned.
Last week, your lordship was there. Your lordship.
There is an interim order. Let it continue.
But your lordship may stay the proceeding because adjournment petition I am filing. They are just pressing that pay the money, the family.
But the regular maintenance you have to keep on paying.
No, I have. Your lordship, just I wanted to say.
This is all areas.
No, your lordship may kindly turn to Annexure 3.
You tell me the
Annexure 3 decree of divorce was passed on 31st January 2022. 17 lakhs was deposited in court. The wife has challenged that in Mata. In Mata, she has confined to only permanent alimony, quantum of permanent alimony. The son and the daughter was getting. Son attained majority, it was stopped. Daughter is still getting 10,000 rupees, which I have paid up to date. I have given the list.
What happened to permanent alimony?
Permanent alimony, she is not receiving. She has questioned that in appeal.
17 lakhs has already been deposited.
Already, I have given the documents.
What is the maintenance amount?
Maintenance is 20,000 to wife, 10,000 to son, 10,000 to the daughter. 10,000 son has stopped because of
majority.
10,000 to the girl child, I am paying up to date, it has been paid. I am only saying the wife is not entitled to maintenance after the decree of divorce. I am covered by 2 judgments of the Honorable Appellate Court. That once decree of divorce is there, the interim arrangement will stop.
That is stayed by the Mata court?
No. In the Mata court, she has only confined it to permanent alimony, nothing else. She has not challenged the decree of divorce.
Right. Mr. Bose and counsel for the petitioner, despite notice, notice has not yet been served. That's the problem. Yes, sir.
My lord, I have filed a memo. She is contesting there. She is well aware. It is reflected in the orders of the trial court.
You take Dasti and serve.
She is not. I cannot. She will not.
Through counsel.
My lord, I will take notice again.
What I'll do is I'll put it 1 week after. Leave this week, next week immediately, and serve through counsel.
My lord, I will take by special messenger.
Special messenger.
Yes.
Right. Then moving an application, that order is already there.
My lord, you are not supposed to stay because once it is stayed, she will come. Because adjournment petition is there, she is playing with the court. And that's why I was requesting.
Despite efforts to serve opposite party number 2, opposite party number 2, no? Opposite party.
Sole opposite party.
Sole opposite party. Service could not be completed. Mr. Bose, counsel for the petitioner, submits that he would serve the opposite party through special counsel as well as through any special messenger as well as through the counsel appearing for her.
Counsel, he will not accept. Your lordship may say special messenger and deposit cost back.
Okay, special messenger. At this stage, Mr. Bose submits that the proceeding before the trial court shall be stayed. He submits that after the decree of divorce granted by the competent court, along with the alimony direction of alimony of 17 lakhs, the opposite party is not entitled to any maintenance. He submits that pursuant to the decree of divorce, he has already deposited the permanent alimony
10 to 22.
on
10
10
to
to
21.
10 to 2021. 10 to 2021. The petitioner has, the opposite party has challenged the decree of divorce, limiting her prayer to the alimony part. Alimony part. Therefore, Mr. Bose submits that after having not challenged the decree of divorce, her right to receive maintenance is seized. In that view of the matter, he seeks an interim direction for staying up for the proceeding. Prima facie, I am satisfied with the prayer made by the petitioner. Accordingly, the trial court proceeding in so and so.
Criminal execution case number 3 of 22 pending in the court of judge, family court number 2, Bhubaneswar.
Bhubaneswar state till next date appeal. Yes. Yes.
Your lordship may say, I'll deposit the cost by tomorrow.
He will deposit. Yes, next.
8.
Yes. Yes, sir.
May I please, Your Lordship? Right, here I am challenging the order of cognizance along with the initiation of the entire proceeding against the petitioner. It is a peculiar case, Your Lordship, where the petitioner is 30 years old, the woman is 40 years old. So petitioner was working as a L&T collecting agent in
What
L&T
are the
Finance.
grounds? It's 376 you want?
Yes, Your Lordship.
Yes.
The ground is that, my lord, the whatever happened, that happened consensually, and on the bare reading of the complaint, on the bare reading of the
Is
FIR
there
itself.
164?
Yes,
No,
164.
first time listed, my lord.
See, annexure 4,
Murder.
161. What she says?
And very interestingly, Your Lordship,
No, no.
34 dates.
I am
She
not
is
trying here.
appealing.
You show me what are the allegations.
My lord,
Cognizance is the right-
376 2N. Yes, first I am coming to the FIR, Your Lordship. Kindly have a glance on the FIR.
No. Come to the charge sheet.
Charge sheet,
has already
yes.
filed. Why to apply?
Runs the right. Page 45, my lord.
Read the charge sheet.
My lord.
Yes.
Is it made out or not?
That should be fine.
Charge sheet, no? What is it?
Come to third page 36.
Yes, Your Lord. I'm coming.
Statement of the victim on 164 CRPC received and the copy of the same. This is the attendance registered from.
85, 37, 164 ton recording that are available on his now putting with the investigation.
You will start researching here or you tell me something?
Yes, Your Lordship.
Tell
Your
me
Lordship.
what is the allegation against you?
Your Lordship, kindly come to page 63 for a moment, Your Lordship.
63.
Yes, Your Lordship.
Yes.
For a moment. Your Lordship.
Yes.
Serial number 21, order dated 16/9/2022. Accused is absent but allowed to be represented on 3171 CRPC today. No PW present. PO is on out on training. Issue summon to the charge sheeted witness fixing on so and so for hearing. Thereafter, Your Lordship, accused is present. 5 Sajida, no PW. Issue summon to the CS fixing. So, my lord, in the meantime, 34 dates have been passed. The victim is not appearing. No charge sheet witness have been examined.
That is something different.
Yes, Your Lordship. And the warrant has been issued against the informant. Warrant has been for not cooperating with the investigation. And the bare reading of the affair.
So many witnesses have deposed.
Yes.
Evidence has come. And she has made specific allegations. And
My lord, on bare perusal of the 161 statement, Your Lordship.
There is 164 statement.
164 statement, I have not annexed, my lord. It
You
is
may
not
not
there.
annex, but that is what the charge sheet says.
My lord, the charge sheet says that, but they are not cooperating with the investigation. They are not coming to the court.
Different story, sir.
Yes,
Not cooperating is different story. But that can't be a ground for quashing.
My lord, on my ground is that
23, my lord. Prima facie, my lord, middle person. ଏହା ଥିବାର ସୁଯୋଗ ନେଇ ମୋ ସହିତ ଜୋର ଜବରଦସ୍ତ କରି ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା।
All these things are there. And
Privacy कैसे will made out?
I know. Petitioner challenge the, will you withdraw and argue all this point at the relevant time?
Then your lordship may target this complaint
no.
case, your lordship,
No, don't.
because in the 161 statement,
Simply dismiss, then you will be.
He's saying that the imbue issued, imbue other provisions are there.
not against me.
Not against him.
No.
Informant is not coming.
Informant
You will
is
be
not
acquitted.
coming.
Why do you worry?
The informant against
Petitioner seeks to withdraw the petition to argue all the points before the trial court at appropriate stage. Hence, the petition is dismissed as withdrawn with liberty as granted. Yes, next. Item 9.
obligations.
May I please, your lordship? My lord, this is an application for quashing the GR case number 455 2021, lordship. Last occasion notice has been issued, and the OP number 2 is entering appearance, lordship.
Insufficient address. You have to give fresh address.
No, my lord, OP number 2 is entering appearance today.
My lord, I'm the OP number 2.
You are appearing. Yes. What do you
I have
want?
received the copy of the affidavit.
And in
also.
this case, the appearance on behalf of the OP number 2 and informer. My lord, today I am filing the IA.
IA कौन prefer करेगा?
IA तो both are settlement, amicable settlement.
joint affidavit देगा ना?
Is there any settlement?
Compromise.
Yes, my lord.
That is my lord.
There is a settlement.
Yes, my lord.
Call them. Call them. So enters appearance on behalf of opposite party number 2 and submits that the in between the parties have already settled the dispute, and he seeks time to what are the offenses?
340 and 320 to 9 for 34.
Seeks an adjournment so that on the next date appearing, the party would be represented before the court. Reach the matter next week. Okay. Bring them next week. Both the matters.
Item 10.
May I please, your lordship? The petitioner filed the case to quash the entire proceeding, my lord.
Yes.
In this case, the co-accused had faced the trial and been acquitted. Here, 100 section 100 subclause 4 of the CRPC, section 42, section 57, and section 55 of the NGFS Act has not been complied. It is recorded in the findings also, my lord.
Ganja and question my lord recovered from his house, my lord.
But the accused are not present.
There, my lord, he has not
How do you think passing?
My lord, accused are not present there also.
I don't let counsel for the petitioner seeks to withdraw this petition to urge all the points before the trial court at appropriate stage. The petition is dismissed and withdrawn with the liberty as read for.
My lord, with a stipulated period. Case of 2013, my lord. Stipulation may be fixed.
Since the case pertaining to the year 2013, it is
one of the co-acquitted.
And one of the co-accused in the present case has already been acquitted. Therefore, it is expected that the trial court shall do well to see that the trial is concluded as expeditiously as possible, preferably within a period of 9 months. From
My lord, 6 months, only 5 witnesses are there.
problem. I'll tell you now. It is unreasonable time. If I give, he'll ask for extension, and for another 6 months I'll give it. But therefore, I am calculatively I'm giving 9 months. I know that what
Only 5 witnesses are there, my lord.
All I guess, no,
Five witnesses.
Only 5 plus, my lord.
Only 5 witnesses.
My lord.
6 months.
I have announcement, all the
6
divisions.
months. 6. Okay. 5 witnesses. Okay.
Obliged, my lord.
Item 12.
Yes.
Yes,
sir.
498A.
498A.
Yes, my lord. Amicable settled between the parties.
Bring them.
I think we are allowed. And forward.
Bring them.
Yes. Tomorrow, my lord.
Not tomorrow, Monday, Tuesday. Tuesday.
ବାହାରେ ରହୁଛନ୍ତି ଆସୁଛନ୍ତି କାଲି ଭର୍ଚୁଆଲ କରିଦେବା
Online, I don't want that. Online also they can appear. Okay. Don't call them unnecessary. That is a matrimonial dispute. Why are you calling them? Online, let them appear. Whatever date suits you, take the date. Online. Are they available today?
No.
2 o'clock.
Today appear कर दो हाँ है पर हाँ ऑनलाइन कौन सी लिंक दे दो
Pass over at 2 o'clock.
2 o'clock
Item 12 ना the both the matters we can dispose here. We bring them at 2 o'clock, either here or through VC, we'll finish.
In BC.
It's 498, Mr. Raghuda.
Madam.
We'll do it, yes.
Item 13.
13 May, Your Lordship.
Yes, madam.
I'm challenging the rejection order of under rejection of my discharge petition under section 239 by learned trial court. So there is no such, so allegation is, but there's no such evidence.
What happened now? The charge has been framed.
No. Charge, investigation has been completed. My
Charge might have been framed because your discharge application is rejected on May 2023.
Charge on the same day, my lord, charge was framed.
Framed, then you file a revision against that. Anyway, do you have a case? Let us see.
My lord, he is
trial
saying
might have been proceeded also.
my lord, they have produced the fake certificate. That is the issue. They are stating that the fake certificate is not fake, it is genuine. So let it be decided by the trial court whether there is genuine or not. That's a documentary evidence.
I have, there are a number of judgment of the Honorable Supreme Court where the facts, allegation are groundless, the discharge.
What groundless? You have got the job by
Producing that fake certificate.
And the thing is that I have never submitted any fake certificate. Rather, I have completed my BEd in the year 2002, and from the year 1907 to 2000, a massive fire incident was taken place in Berhampur University, my lord, where all the certificate regarding
which year?
That is the page number.
Which year massive fire?
That is 2002, my lord. I think 2000.
So therefore, you have prepared a certificate yourself.
Where my original records, all the records pertaining to BEd and
Madam, those things are factual disputes. You have to lead evidence.
My lord, if your lordship see, just a minute, I just would like to take your lordship to the page number.
My lord, court cannot conduct a mini trial at the time of framing of charge.
That for her satisfaction, he argue. What can I do? You know your limitation also, my limitation.
I am just stating the fact, my lord.
Those facts to be tested, madam, in the trial.
Your lordship may keep it other there. I'll bring, because there are a number of judgment of Supreme Court where the rejection order of discharge petition is passed by the Honorable Supreme Court, my lord. And one I have also.
Therefore, I'll pass a judgment. You go to Supreme Court. I'll simply adjourn you. You don't have a case. I'm simply adjourning.
And lordship, your lordship, I'm just producing a judgment
on the facts
Supreme
of your
Court.
case. The judgments may not help. The facts is so, no.
I'll keep it any other day, my lord.
I'll just adjourn it after a week or so. You prepare it, but on facts you don't have a case. That's the problem. Maybe the judgment which you are reading, the facts are different. Anyway, we'll see. Yes, next.
Item 14.
Simply adjourn on request. Huh?
My lord,
Yes. Yes, sir.
the petition before your lordship for passing of a cognizance dated
Yes.
16/9/2022.
What are the offenses?
Offenses under section, your lordship,
323, 294, 427, 34.
Yes. Why should it be quashed?
On the basis of compromise, they have filed annex of
compromise already been done.
Then
Thereafter,
I'll issue notice. I'll issue notice if compromise has already been taken place.
again,
Let us issue notice. Call them.
under annexure,
Let
your
counsel for the petitioner submits that the parties have settled their dispute. On the basis of the same, he seeks indulgence of this court for quashing of the cognizance order. Issue notice to opposite party number 2.
I have
Bring him next week. I'll quash.
my lord.
I'll just issue notice. Bring him, and 1 week thereafter you put it.
My lord.
Bring him. I'll quash it.
My lord.
Yes.
Item 15.
The requisite.
May I please, your lordship?
Yes, madam.
My lord, I'm challenging the annexure 3, where the recall petition of 5 witnesses under 311, it was rejected. This is a case of 302 matter, my lord, and 19 witnesses have already been examined. Out of these 5 witnesses, they cannot
Where is your application? The application is
challenging the recall petition was rejected, my lord.
I know.
That is my annex to page
Annex
16.
three, Annex 3.
Page 16. Come to
Page 16 is the petition, my lord. 311 petition.
Page 17, my lord.
Why have you not cross-examined them?
My lord, they were already cross-examined, but they could not be confronted with the previous statement which was
Why?
made
That
before
is, see, these people were
inadvertently, my lord, it was
examined
happened.
in 2019, 20 and all. You have not given any reason.
Yes, my
Also,
lord,
they
but
were
inadvertently it could not
they
be.
are not confronted with the contradiction.
Yes, my lord. But there is a heavy material
Yeah, my
contradiction.
lord, 5 witnesses, they want to recall the 5 witnesses which has no evidence or value at all.
Only with
First
one
trial.
condition.
Basically, again,
Which has no evidence or value at all.
because the lawyer might have been changed. You might have engaged a wiser lawyer now. He might have said that what kind of cross-examination you
You are
My lord, this is
Not
the
application.
302 case, my lord. Heavy punishment is
No,
there.
but you tell me who, how many,
My lord, only single opportunity may be
one
given.
minute. How many witnesses you are seeking?
5 witness. 3.
Who are the main witnesses? You tell me. Don't en bloc ask for it. One witness,
My
two
lord,
witness. I can,
PW3 is the informant. PW3 is the
you
informant.
decide, madam. You decide. You seek recall of PW3,
3, 4, 6, 7, 8.
3, 4,
6, 7, 8.
6, 7, 8. 4 witnesses. You want recall.
5 witnesses.
5 witnesses. Who all are the very important witnesses? You tell me so that I can allow 1 or 2 and rest I'll. You decide. And you ask the lawyer, trial court lawyer, instead of asking all the 5, let us concentrate on 1 or 2.
My lord,
I'll do it.
My lord,
my lord,
subsequently, my lord, they will come another for another.
No,
5 witnesses.
I'll seal everything.
my lord,
There.
if given a chance, all those 5 witnesses will
5
be examined in
witnesses
one day, my lord.
and block. See your application. This application, reading this application, I can reject it right now. Just see the application, page 16. Read it. This application, which court is going to allow?
My lord, some
Tell me a single whisper about treason.
My lord,
What
some-
you want to confront? What are the evidences? Nothing is written here.
only for the purpose of contradiction, my lord. If
You simply write they were examined in 2019, 20 and all. They were not confronted, so therefore I want to confront. That's all. What was the evidence? What are the contradiction? What do you want to confront? Nothing is there.
My lord, if it is required, I will give the questions to the lower court. If lower court will scrutinize, my lord, only material
Do
contradiction
you
will
want
be
me to
asked.
reject right now? Or you will exercise the option and come next week?
Definitely, I'll exercise the option, my lord, but
1 week thereafter. You think over and come.
oblige, my lord.
And think over which witness will be very relevant for you. At least 1 witness, 2 witness, because 302.
My 302.
Has a right to defend himself.
Yes.
The best witness you want to be recalled, then I'll allow 1 or 2 and rest I'll reject.
Obliged.
Yes, because your application is very pathetically drafted.
My lord, next week.
Next week, not next week, next to next.
Okay, any other date, my lord.
You think over, read at the entire evidence of all the witnesses.
Yes, my lord.
There may be some formal witnesses also. Because the application is moved without application of mind. Simply, laga to sare.
No, my lord, only
type.
main material contradictions are there.
If permits, my lord, may assist my learned friends in 1 minute. Let my learned sister also examine the order rejecting an application, section 311, my lords. Whether it's an interlocutory order or not. I've got the judgments, but let her examine all this.
That also
Next
you
one.
read it. This is the senior is advising something.
Yes, my
to
lord.
read.
Yes, my lord. Obliged.
Whether it is an interlocutory order or final order. If it is a final order, if appeal is not provided under law, then revision lies.
Yes, my lord.
That is why he says, read it.
Obliged.
Yes.
16.
My lord, the prayer is to quash the charge sheet.
Yes, sir.
For the petitioner, and the petitioner along with 3 others, they are indicted on the section 468, 420, 471 as well as 120B IPC. And the advocate and the petitioner is an advocate by profession. And the complaint was lodged by the sub-register Bhotley on 19/10/2020. He lodged the complaint.
Who is the informant?
Informant is the sub-register sub-register Bhotley.
You have to implead him.
No, I have not impleaded him.
You implead and issue notice because he is a lawyer. I will see what can.
Only his prayer is to finally to quash the finally report, man.
What the
Finally report? This is not final report. This is final report. See, final report, he has no case, madam.
That's right, but he is a lawyer. What? Final report, huh?
Annex 2.
Final form, just a check. Final form, final report. Final form and final report.
Yes, ma'am.
What are the allegations? Let us see.
The allegation is that
you do one thing. You implead the opposite party informant. You implead the informant and issue notice. Then counsel for the petitioner seeks to implead the informant as opposite party number 2 during the court. Right now you do it. Issue notice to the newly impleaded opposite party number 2. He is a lawyer. Let us see what can be done.
He has, my lord, filed that forged affidavit. That is the reason.
Your lordship, he did not file
Yes,
any
my lord.
false affidavit. In fact,
See, there are a lot of limitations for a lawyer, you know. Trial court lawyer, lot of limitations.
in fact, somebody else identified it.
Don't stress further. You please, sir, we'll see. If anything can be done, we'll. Yes. Upon informator address and everything you write, file the process fee, and we'll see once he comes, we'll try to find out way. Yes. 16? 17. Yes.
May I please? Here the petitioners. The petition number 1 is the lecturer of anthropology and serving at Kolan University, Jharkhand, Millard. And petition number 2 is the old father, Millard. They have challenged the order of cognizance as per Annex 3, Millard.
Yes.
Here, this present issue arises by paternal property, Millard. Paternal property has been partitioned between the brothers, Millard.
Your opposite party number 2 is your brother.
Brother's wife, Millard.
Okay.
Brother's wife.
Security. You
My-
have deprived her from all the properties.
During the partition, the land which falls
Okay,
in my
I'll
share.
just issue notice, family dispute.
My lord.
Issue notice to opposite party number 2, returnable within 2 weeks. 2 weeks, huh? So and so accept notice for the state. Yes.
I'll stay up for the proceeding.
No state. I'll pass it straight away.
This cognizance of the year 2020.
I know, I've seen it. You serve, let them come. I'll send it to mediation. If something can be worked out, nothing. Yes.
18. May I please, madam?
Shall I, 1 minute, shall I send straight away to the mediation without?
Yes, my lord. It will be better. It will be better, my lord.
Because she is the wife of the brother.
My lord.
And these
It will be
two
better.
people are brothers.
My lord.
Ancestral property.
My lord, it will be
These
better,
people
my
might not have given anything.
My lord.
I'll send, I'm issuing
Mediation,
notice. At the same time, I'm referring you to mediation, and you go, and if anything can be worked out, nothing.
My lord.
Since the petitioners are the brother-in-law of the opposite party number 2. The dispute appears to be a dispute appears to have been caused due to the property distribution, regarding the property distribution among the family members. In that view of the matter, I am of the conscious review that the matter could be amicably settled through mediation. Therefore, the parties are relegated to the High Court Mediation Center. They are belongs to where?
Rairangpur.
Rairangpur.
My lord.
So district mediation.
District
center is
mediation
better-
center, yes.
Rairangpur district.
My lord.
Uh,
No,
uh,
district
Moyurbhanj.
Moyurbhanj. District Moyurbhanj.
Moyurbhanj. Okay. Relegated to the district mediation center, Moyurbhanj. The coordinator of the mediation center shall fix a date of settlements, date to explore the possibility of settlement and intimate the same to all the parties, and after the mediation, mediation center shall produce a report before furnish a report before the court, awaiting the mediation report, leave the matter also. ऊपर जो notice रहेगा, you issue notice also and counsel for the petitioner further submit that he would communicate the present order to the opposite party number 2. Okay.
Problem.
Yes.
Item 18.
May I please, madam? The petitioner files his application for challenge the order dated order dated 24/5/24 was rejected the application under section 311 for recalling the PW6 matter. Only one witness they want to recall matter. Put only one question matter.
Who you are the accused, huh?
Yes, madam.
Offense?
302 for Odisha prevention of
which active act?
My lord, here, my lord, the PW6 was examined on 19/5/22. After 2 years, here, my lord, prosecution has closed its evidence. Defense also closed its evidence. Now the case is posted for argument. After 2 years, is filed this 311 petition. Though all were examined, my lord, but they have examined they recall the PW6. They recall the PW3, my lord. Earlier, they have recalled the PW3, but they are not whisper about that PW6. Now they are filing a petition that to recall the PW6.
Why
At the stage of argument,
well, senior counsel was ready for arguing, found that this is a defective and a confront is there, should be there, matter. One question, matter. The informant not stated in the FIR as well as 161 statement and 164 statement that they are beaten him.
Whether PW6 has stated before IO or the magistrate.
Yes, my lord.
Mentioned in FIR.
Accused persons were taking Jagabandhu being beaten himself to the village cremation ground. It is high court again. I say 164 my lord कहनी 164 my lord कहनी साक्षी कहिस मतलब that should be confront my lord.
No, don't you think that this question is
relevant?
Not necessary, my lord. Necessary is not.
Only, my lord, to lingering the matter, though it is posted.
Only one date. No, one date I will.
No, 1 date or 2 date is not more important. Important is in the 311 application, I have to see whether a substantial prejudice is causing you a proper defense is being.
And for just decision of the case.
Just decision of the case. Just see the question.
Yes, my lord.
If you don't put that question, what will be the consequence? See, read the question. Whether PW6 as stated before IO under 161 CRPC or the magistrate under 164 CRPC and mentioned in the FIR of this case, by that time accused persons were taking
Jagabandhu being beaten himself to the village cremation ground.
If they have not said, they have not said.
No, sir.
These are the documents you can see.
They have not said. They have not stated in 164, but Sakhire कहते Sakhire PW6 टा कहते से नुआ कथा टा मैटर. This is the new fact.
So show me PW6.
Yes, madam.
Statement.
Page 11 relevant portion, madam. We noted ourselves bottom of the first para 11 page 11 bottom of the I and Sukri came to police station and found, my lord.
This is the evidence.
Yes, my lord.
These are 161.
Page 11. Page 11 is the evidence of the PW6, my lord. Page 11 kind of paros. Accused persons detained Jagabandhu being tired called my elder sister Sukri Kumurika from village Bandhaguda. She came and requested the accused to leave Jagabandhu. By that time, accused persons were taking Jagabandhu being beaten himself to the village cremation ground. It is a cohich manner. But how could you coin 161 coin 164 be coin manner?
So after 2 years where the argument is posted for argument, you will recall that person.
No, only one day.
313 has already been done.
On that day also argument will be started matter. On that day Sakhi is argument start is matter.
And before that matter, they have also called PW3. They have not whispered about PW6.
Sorry,
what I am suggesting is the day when it is fixed for argument, on that day, same witness, same one question should be put.
Yes, madam.
Only that question. You will also may confine only that question.
Yes, madam.
Why to leave it like that? In this sense, these are very serious cases in the sense
Yes, madam,
302
yes,
and
madam.
all.
Numbers of people, madam, accused
Petitioner
persons
moved
have.
an application. Petitioner moved
No,
an
six,
application under
six,
311.
6 persons also is there, madam.
Petitioners have moved application under 301 CRP, 311 CRP, seeking the recall of the
PW6, the informative.
6 to confront with a singular question, which is paraphrased in the application, which reads as under. Page 13 of question. Page 13, that question is there. Only one question. And counsel for the state submits that the trial has already been concluded. The prosecution evidence has already been concluded. The statement of the accused under 313 CRP has already been recorded, and defense also closed his evidence. At this stage, the present application is moved. Therefore, the trial court has rightly rejected the same. Counsel for the petitioner has taken me to the evidence of PW6 to impress upon the fact that the question framed to be posed to the witness is in fact a relevant question. I am satisfied with the submission made by the there is a merit on the submission made by the petitioner. Hence, I am of the considered view that when the matter is fixed for final argument, on that day itself, the PW6 may be recalled to pose the singular question, which is mentioned in the application under section 311 moved by the petitioner. Accordingly, the trial court, so court is directed to recall PW6 on the date to be on the date fixed for the final disposal, final argument. On the same day, the petitioners shall be afforded an opportunity, single opportunity to pose the question as framed by them and found mentioned in the application. It is made clear that at no circumstances the petitioner shall be allowed to allowed to seek adjournment on any ground whatsoever. Any ground whatsoever.
And not to put, my lord, any other question.
A singular question.
Single question.
I have said. Only one question you will put on the day when the matter is fixed for argument, and thereafter argue. Yes.
19.
May I please, your lordship, my lord?
Yes, sir.
My lord. This is, my lord, my application for interim release of the vehicle, my lord, seized in connection with excise case. I was praying for interim release of the said vehicle, as the vehicle remains idle for 1 year, your lordship. And
you are the owner.
I am the owner, your lordship.
And the accused.
Owner, yes, yes, your lordship. And the vehicle is an hypothecation, my lord.
It's a excise act section 72 is bar. And confiscation proceeding is going on, and the report is that, my lord, this vehicle is required for further investigation by the
confiscation proceeding is going on.
My lord, that is number is
going
2 by 23. And he may participate in the confiscation proceeding. He's not participating.
You won't participate, but
I am participating, my lord. But in spite, my lord, several judgments by this honorable court for interim release, my lord. I am not applying for formal release.
Even if I allow subject to outcome of the confiscation, what is the meaning of that? Nothing.
At least livelihood, your lord.
What is the stage of confiscation?
My lord, stage is matter not written. Your lordship may direct to conclude the confiscation proceeding within a specific period. He may be participating in the confiscation.
That's a better idea.
From 1 year, my lord, going on.
No, I'll direct that to conclude it in a month, within a month.
Within 2 months, my lord. Within 2. That is 2 by 23, 24. Your lordship may say. Your lordship may.
1 month, let it be late. One.
And he has to participate in the confiscation without.
Confiscation proceeding is not a very big. It's
no, my lord.
Summary proceeding.
My lord, much more cases are there for confiscation. It will be difficult.
It is agreed by the order dated 22/4/2024, passed by the second additional sessions Judge Cuttack in criminal revision petition 96 of 2023. whereby the order dated 12/10/2023 passed by the JMFC 1 cognizance taking Cuttack in criminal this case number 109 of 2023 has been confirmed. The petitioner moved an application under section 457 CRPC seeking release of the vehicle, release of his vehicle number so and so. The petitioner claims to be the owner of the vehicle and who is also an accused in the FIR number so and so. FIR number so. Then counsel for the state submits that the confiscation proceeding has already been initiated against the petitioner for the said vehicle being confiscation proceeding number
CP number 2/2324.
CP number 2/2010. And he
2324.
He further submits that the petitioner is not cooperating in the pending confiscation proceeding. In view of the fact that the confiscation proceeding has already been initiated, I am not inclined to entertain this petition at this stage. However, petitioner is given liberty to contest the confiscation proceeding, and the who is the authority? The competent authority.
Competent authority,
Who is
my
that?
lord, that is
Before
authorized officer cum EDC.
authorized officer come EDC.
Bracketed CD. Bracketed CD.
Packet CD is directed to conclude the confiscation proceeding within as early as possible, preferably within a period of 1 month hence. 1 month from the date of receipt of the present application. With this observation, the petition.
And petitioner shall not take several adjournment. Because you will take adjournment.
Petitioner shall not unnecessary seek adjournment to prolong the proceeding.
They have not noticed yet, my lord.
Now you want
They have not noticed. Mandatory
Yes, I have written now.
71(4), section 71(4), they have to notice first. To explain why the
My lord, I
proceedings
would
are initiated
in
against
the order, your lordship directed that written that it is JMFC 1, that is JMC 2, my lord.
What? Yes. Bail matter? No, bail matter starts from?
Item 20.
20 টা say
20 টা अलग है।
3 matter
proceeding to charge.
Item 20, your lordship.
20.
Same type case, but the vehicle is in custody, my lord, since 7/3/23, and the owner is not accused in this case, my lord. Final PR has already been submitted 7/3/23.
So
And confiscation is going on, my lord.
Owner, I was 20, item 20. He claimed to be the owner. So accused victim, he is not an accused. So request कर दो, ठीक है?
21.
May I please, Your Worship? I have the
Yes, sir.
this matter relating to proceeding under Domestic Violence Act. Proceeding under Protection of Women under Domestic Violence Act. Yes, ma'am. Here the petitioners before a lordship, they are not the they are the in-laws staying in separate mess. She has specific claim against
Who
the
has
husband.
who has initiated the proceeding?
The
Opposite part number 1.
OP number 1. And here earlier she filed one proceeding, and in respect of the present petitioners, she filed a memo for withdrawal. Before the
What happened to the matrimonial dispute?
matrimonial dispute, that is not there.
There is no dispute.
No.
Husband, wife.
Husband, wife, they have got their dispute, but no matrimonial suit or divorce proceeding.
And issue notice, let us see.
Your Lordship.
Issue notice to, because it's a matrimonial dispute, unnecessary. Why to complicate? Call them.
Not the, no, here the, yes.
TV case only.
Here the husband is not before your lordship. Husband is not before your lordship.
Husband will come.
In respect of the present petitioners, she first withdrew the case. Thereafter file another.
Anyway,
case.
issue notice. Issue notice.
And file an IA for stay of further proceeding.
Issue notice on IA. Yes.
Lordship may say grant stay of further proceeding because we will have to go to Sunargarh. We are from Berhampur.
You, Mr. Mahapatra, land counsel for the petitioner, submit that he would move appropriate application before the trial court seeking adjournment in view of the fact that the matter is sub judice before the court. He may move such application. If such application is moved, same circumstance. Yes, next. 22.
May I please, your
And
lordship?
thereafter you don't file process, huh? Don't file requisites. I'm saying don't file requisites.
No,
And
no,
send the junior.
No, I will file.
Because this interim order, that is the danger involved. After 5 years, requisites are not filed, matters are pending.
No,
Stay continue, stay continue.
I can assure that by the next date, there will be no office note that requisite not filed.
And if go and serve them so that let them come, we will try to settle it out. Yes.
May I please, your lordship?
Yes, sir.
My lord, in this case, the wife, when she was 2 months pregnant, the husband, the accused, brutally assaulted and accused her and kicked her belly at that time. And on the next date, he drove her out from the house.
What do you want?
My lord, that section attracts 313, but
173(8) is open. Why are you?
my lord,
Because in the prayer you have seen.
my lord, the police personnel didn't enter the
Directed to
313.
conduct further investigation and
Yeah.
submit additional charge sheet. No court can give a direction to the police whether do further investigation or what.
My lord,
We are not, courts are not here to control the.
my lord, the police
investigation.
personnel are not listening to the party and they are.
Now the prosecutor is there, he will listen and convey it. But there can't be a direction.
My lord, they are destitute and they
Yeah,
for the
understand.
justice we are here, my lord.
Understand, but what I'll do is, you withdraw this with a liberty to submit this thing before the police and let the police take the.
My lord, kindly.
It was submitted deleting the 313
313.
offense, so though there is no
Protest
such
petition, he
evidence.
can file, so many things are there.
My lord,
says
he has
that-
not applied before the court below, directly come to the court that
No,
for further direction.
my lord, case is going on in SDJM for PS
where is the
number
petition?
36. It's already going on, my lord.
Move
But
there.
Where is the petition that?
my lord, kindly, if my lord, it's a discretion of your lordship.
We can't give direction to the police for investigation.
Further
My
investigation.
lord, after so many times of non-listening of the police personnel, that's why we are here, my lord. That's
Letter counsel for the petitioners seeks to withdraw the present petition to move appropriate application before the court below. Court below is for any such raising all these points. If any such application is moved, the same shall be considered on its own merit. You move application. The trial court may give some direction. Take.
Wait, please, your lordship.
Yes, sir.
Here I have challenged the order of framing charge on the ground of my lord, exoneration of the petitioner from the departmental proceeding, my lord. I have annexed the documents are at page 32 to 59. Even my lord, the vigilance inspector has also been examined in the proceeding. Ultimately, my lord, I have been exonerated. My lord,
Departmental proceeding.
my lord. But that has not been considered by the.
Are you relying upon that Radheshyam?
I am relying upon.
Yes. He has taken that.
Radheshyam.
Yes,
my lord, Kejriwal.
But those things are
Radheshyam and
adjudication proceeding. These are not departmental. If
my lord,
adjudication proceeding, if you
I-
are exonerated,
my lord,
then the criminal prosecution
I am
cannot.
relying upon the judgment of this honorable court which I have argued, Minaketan,
Minoketan.
my lord. That has been taken note of by Honorable Justice S.K. Sahu. That is also, my lord, with regards to disciplinary proceeding. My lord, 2022 volume 2 OLR 61.
Minoketan, no?
नहीं
Satyasri.
Satyasri Mahapatra. Honorable court was pleased to take note of Minaketan, Radheshyam Kejriwal and Ashu Surendranath.
Radheshyam will not help because Radheshyam is the adjudication.
My lord, 2022, that is Ashu Surendranath, that is also important. If my lord don't see the judgment.
Where does it say that it is departmental proceeding?
My lord,
Minoketan.
Minaketan is, my lord, reported in 2022 volume 2.
Disciplinary proceeding and the criminal proceeding can be launched simultaneously. Everything to be contingent reached by the.
Well, that has been exhaustively taken note of in paragraph 4, ballot basic.
Para 4.
Well,
Yes. Everything to be contingent reached with the responsibility.
and ultimately, ballot at page 635, in the case of
Yes. What is it?
And ballot, one thing I want to draw ballot's attention. I was also going through the judgments of this honorable court after Minakatan Pani. One judgment by Honorable Justice R.K. Patnaik.
What is the stage of the Minakatan was tasted in the Supreme Court?
Minakatan was
tasted in the Supreme Court.
I don't know whether they can say.
Yes, Mr. Das. Minakatan was tasted in Supreme Court.
Yes.
What happened?
Result I will appraise your lordship. But if a lordship permits my lords, the lordship can turn to the impugn orders first.
Yes.
Impugn order, if a lordship turn to lordship, impugn order is 64. In fact, it starts from 62, my lords.
Yes, 62, 64. Yes.
Lordship, you can see the date of the impugn order, 3rd July 2023, my lords. Here the order of by which the charge has been framed, my lords. After the framing of charge, usually the trial begins, my lords. Now, after 2 months of the beginnings of the trial, particular trial, my lords, now lordship can turn to the department in the department proceeding, my lord, was ended, my lord, with a censure, my lords. That is on 5th September 2023, 2 months after that, my lords. Now the trial is going on. Now he has come back.
Who says the trial is going on, my lord? This is not the question which has been put by my lord, my lord. Here, my lord.
Let me answer.
In Minakatan Pani's case also, Honorable Chief Justice, my lord, while I argue the case, that was also ended in censure.
No, so for the
Listen, listen me.
Matter, I will answer to your lordship.
No, let me complete.
I'll simply issue notice because prima facie there is a case. I'll issue notice.
My lord, it's a Minakatan Pani, my lord, I had challenged in the year 2005.
Minakatan by please, 482. Not on the revisional jurisdiction. Order.
It's not a revision. It's not a revision.
2 grounds, any orders, framing charge is being interfered on the revision jurisdiction on 2 grounds. Patent
it's not a revision.
Sir, you answer it.
My lord, it's not a revision. It's a criminal miscase, my lord.
No, criminal revision. You are
by the order.
Criminal revision file.
No, my perhaps you do not. This has been called, my lord.
It is 536.
536, yes. Well, some cases.
It's a revision case.
Some cases, my lord, Honorable Justice Mahapatra is converting the cases to criminal miscase for that reason. 3 of my cases challenging revision. He says 482.
See that objection can be taken care of. He can file a 482 to get it tagged also.
No, that is not a problem.
I'm on the threshold, my lords, when invoking.
You say that revisional jurisdiction is limited, so you can.
Secondly, in the trial,
you are right.
This issue can be raised as a defense.
Why? How in the trial? How in the trial it can be raised?
This particular order by which he was let off, Lord, you want to encash that one.
No,
it can be additional evidence.
Where is the departmental proceeding? You have been completely exonerated.
Yes. And the same sets of the same sets of fact or not, Lord, that has to be adduced and factual adjudication required.
32 Madam Messi.
Who is to examine? Where is that? What is the mechanism to under the High Court?
All right, I'm issuing notice. I'll issue notice and stay the proceeding and argue on this because I have also given a judgment in this line. Taking Radhesham and all, distinguishing the departmental proceeding and adjudication proceeding. In those proceedings like FERA and all, there are adjudication proceedings. Adjudication proceeding, you are exonerated, you get the benefit. But there are similar line of judgment where a departmental proceeding, you are exonerated, whether that benefit can be, because standard of proofs are different. That is, but Minakatan is directly in your favor, and this judgment is also directly in your favor.
And that,
And also I am,
that case has been
also I am
filed to
submitting.
82 million.
Please,
Then
please.
let my learned
Let
friends
me,
take
let
the
me
step
observe, Mr. Das.
for conversion.
482, see,
Yes.
482, the objection which you are raising 482,
Scope is
that
very,
is a
very
technical
limited.
objection that can be taken care of. That's
Yes,
not,
only on 2 grounds, my lord.
the idea is if the same set of witnesses
Correct.
in a particular proceeding has gone and said something,
Just you don't judge
and
this,
on the
my lord.
basis of the same set of evidence, if you put them to trial, what is the end result? The end
Agreed,
result is zero.
Agreed, my lord.
So
But-
therefore, it has to be quashed.
But
That's
that
the idea.
that should be under 482, not under the revision jurisdiction.
ठीक है those things right now issue notice नहीं Mr. Dhal and counsel for the petitioner submits that on the same imputation of charges the petitioner was subjected to disciplinary proceeding subjected to departmental proceeding the departmental proceeding. After the examining the witnesses by the inquiry officer, the petitioner has been exonerated, completely exonerated in the disciplinary proceeding. Therefore, relying upon the exoneration order in a disciplinary proceeding, he assails the criminal prosecution initiated against him in the present proceeding. Mr. Das and counsel for the petition submits that
Trial comments, my lords. This is a defense plea.
This is a petition. This is the revision petition wherein the application for discharge moved by the petitioner has been rejected. Has been rejected.
Charge has been framed.
And subsequently charge has been framed.
Which is impugned in these revisions.
Subsequently charge has been framed and the charge order is impugned in the present proceeding.
And trial in the consequential commences.
Mr. Dhal is relying upon two judgment of this court reported in Minakatan Satyasri and submits that in both the cases this court have quashed the entire criminal prosecution on the basis of relying upon the exoneration orders passed by the departmental proceeding. Prima facie, I am satisfied that the case for the petitioner is covered by the two judgment of this court. Hence, issue notice to the Mr.
Your Lordship also
Das
kindly
accept notice.
record back to I rely on two judgment of Supreme Court. So Lordship can only record my submission. That I rely on judgment of Supreme Courts, where Supreme Court said in case of an ordered framing charge can be
citation.
I'm giving the citation.
By contrast, Mr. Das also relying upon two judgment to controvert the contention raised by Mr. Dhal.
That an order impugning and order framing charge can be challenged on two grounds: one in palpable errors of jurisdiction and in rarest to rare cases modes. Lords, you can record it.
He submits by relying upon those judgments. He says that the order of charge could only be questioned in a revisional jurisdiction limited on two grounds, namely
in a rarest of rare cases.
Rarest of rare case.
Two, if there is a patent error of jurisdiction.
Rare case is
capital
punishment.
Well, under Article 41 is staring all of us.
Capital punishment. Okay. This is your submission.
This is my weapon at my hand, sir. That can be pressed into service.
Issue notice. Returnable within 2 weeks. I am putting it 1 week thereafter so that we will finish it up.
Yes, I will.
And in the meantime, the trial court proceeding in so this day. Yes.
And my Lordship, I will simply request my learned friends, learned senior lords, because in other two cases he has prayed an application for conversion. There is no impediment for him to convert and get the benefits.
I have not prayed.
Neither you nor I. Both of us can't advise him.
No, it's a
He knows
suggestion.
what to do.
Let him reject, my lord. This is another thing.
And you raise the objection, he will meet it next time.
He cannot meet because that is Supreme Court judgment. No, revision jurisdiction scope is very limited, sir. I should not tell about the elementaries.
He will face the worth of it.
I should not tell about it. He is a quite learned person, my lords. I learned law for me, but the revision jurisdiction scope is absolutely limited, my lords.
Yes. Okay. Next.
May I please?
Yes.
Lordship, remember that.
There is waiting for which matter?
My lord,
Huh?
It's not that, that is why I am
Okay,
waiting.
okay.
My lord,
24.
My lord, this is 24 if my learned friend submits, my lord. This is that case, I should refresh your lordship memory. This that
Release of laptop, my lord.
cryptocurrency market matters, my lord.
Well, release of laptop. Your lordship kindly see, the petitioner is not an accused.
No, I'll tell you. It will take little time.
I'll
just put it.
I'll also get the status reports, my lord.
Status report. Mr. Das, Land Council for the
six-
petitioner
on-
seeks 1 week time to get the status report in the present case. Lease the matter after.
Your lordship on
1
16 July, time was granted twice, my lord.
Twice,
And
you have-
your
this
lordship
is-
kindly have
this
a
is
glance
not an ordinary
on the order
case.
dated 16/7 only.
Take it, I'll take this time.
16/7.
1 week.
No, the software
And
engineer
by
coming
this time,
from Bombay,
he
my lord.
will lose the job.
Waited for such a long time.
In this process, he will lose the job.
No, he let him lose his job. That particular
That
thing is
laptop,
going to
Why
service.
he will lose the job?
No, yes.
He is not an
Because
accused, my
this
lord.
particular
And the
thing is
laptop,
placed into
they have
service
seized
to-
the laptop since last
I
2 years.
know this is a
And
hard.
2 years took,
No,
they took time 2 years.
1 crore.
How it will not solve the problem? See, the issue is he is the son of the main accused.
Yes.
If I
And this is the
recollect.
company laptop.
And he has a laptop.
Who asks you to use it particular?
No, he has not used. He has not used.
The illegal waste. Yes.
Next minute. Yes.
Alright, here also I am.
Why have you listed all the difficult matters today?
No, in fact, we are great friends.
Yes.
But this is also a case, my lord, my learned friends come up against an order, reject listed application, not on the frame charge, my lord. Coming for the first time, my lords. If I can argue that much.
I'll issue notice.
Here also I am covered by 2 judgments. Why?
Giving the judgment, just verified.
Judgment, I'm
Yes,
issuing
if it's
notice.
applicable, then
your
not.
lordship, another, that wife is been added under 109.
109.
Yes.
But here is a income. Mr. Rathan knows that, my lords. You can turn to the page 4, my lords. Page 4, my lords. Here the accused is a businesswoman and an income tax assessee, my lords.
It's even I'm in a better position.
No, he's a worse position, sir.
See,
Very fair.
My
109, 107.
I'll tell you, my judgment of what I've said is, if the wife
Yes.
doesn't have a independent defense,
100% dependent.
independent defense,
Yes,
he is not putting forth any independent.
No independent defense.
Then her case is that whatever accumulation of assets is the husband's asset, I have nothing to say. Then husband has to face it, wife under
Exactly,
aid of
my lord,
109, you can't do it.
That's my only case, and that is there.
No.
That is
He
the
says that
tactic.
I'm a businesswoman, pay income tax and every month. That you have your own source of income.
I am a
Pay-
housewife having landed property under rented.
No, business you are
Forget
mentioned.
about that.
Anyway, are you paying income tax? Are you paying
I
income
am
tax?
paying income tax. Well,
You may not be covered under that.
my lord, everything.
I'm issuing notice.
I agree.
Yeah, your lord.
Issue notice after 2 weeks.
And then, yes.
I also verify if there is any scope. Then.
If there is any
But-
scope,
But that stands on the way. Your lordship judgment cannot be
No,
encashed
no,
by him. The
talking
reason being, he also said that he's paying
sir,
income.
try and find out some way. If we can give relief, why not?
Definitely.
That's the idea.
Pratima Behera and other
And
cases of-
if somewhere some scope is there, try and
Find out
assist so that we can try to
In fact,
give
we
relief.
both will explore the feasibility
See,
of
you know, Indian society, what happens?
ଗୋଟେ word
Wife-
ଯଦି ଆଜ୍ଞା
wife-
abatement instigation ଥାନ୍ତା ମୁଁ ଆଜ୍ଞା କହିନଥାନ୍ତି।
Wife, actually, in our society, wife in 100% cases,
Agreed.
wife has no role.
Agreed.
Husband does everything, and
Agreed.
wife is unnecessary, you know. So, if there is any scope, please tell. So
I
that
will definitely explore those. I'll come back to your lordship with positive instruction.
in any case, the husband has to face the music. Let him face. Why should the wife will unnecessary?
Correct, my lordship.
Yes. Yes.
36.
Lord, this is the petitioner, my lord. Challenge the order of the special judge vigilance, my lord, at annexure 11, by which the London court below attacked the property of the petitioner. He was no way connected with the no way got the offense, and this is the acquired property, the absolute owner of that property, and that property has not been seized, but it was been shown in the prosecution report. And I have been filed objection to that. That property has been purchased by my grandfather, one by minorship. Thereafter, it mutated my name, and that money has been paid my grandfather out of his own income by way of a bank draft. Thereafter, I may applied for the loan I'm my income tax assessee, and I have been taken 14 lakhs as a loan, and this property is still mortgage. Even that my property has been included because the opportunity party number 2, the accused is my father. Absolutely, I don't have. I don't know. I'm not.
Where is the impure order? Which one?
That
153, 153.
23, but 153. That was 123.
Annexure?
Annexure 11 at page 153 million.
Yes.
That is 23/12/2003, and the ordering person will at 155.
You are
Exemption of the entire material privacy as the scheduled property acquired by the opposite party even disposable are known sources from the income to opposite party number 1. It is absolutely a prejudged observation, and this property is the property of the son. It was acquired by, it was been purchased by the grandson. It was property by the maternal grandfather, and when he was working as a foreman in the Tata company, and this property has been purchased the name when they are the minors. There was a mutation there.
What is this order then?
Then order they attach my property. I'm neither as a cited as a witness nor as a accused, nor this property has been seen.
Necessary that you.
May I submit, my lords? I got a lot of respect, Mr. Mahapatra. We work together as government lawyers. My lords, you can turn to page 153, my lord. Once again, my lord, I place us first 2 lines.
Yes.
First line, the line starts, the petitioners have approached the court to pass order regarding the attachment of property under section 3 of the Criminal Law Amendment Ordinance 944. Yes. I'm holding that book, lord's book. That book is besides a lordship book, lords.
Really?
Section 3, my lords, the section 3 of the 44 ordinance says application for attachment of properties. State preferred petition. In that petition, on the section 4, my lords, on order 4, my lords, he had filed an objection, my lords. Now, this order is not revisable, but under order 11 appeals that. He has to file an appeal, my lords. Let him take instruction, lords.
Section 3, subsection 3 of the section 3, my lord.
Section 3?
Of the subsection 3.
Yes. Section 3.
Mind that I am not the person, and I am not committed a schedule offense. And this application is thoroughly misconceived.
You are relying upon your own book, it seems, Mr. Das.
Yeah, my lord. Page 48, my lord. The
48.
The second part of the book. Page 48
of the
48.
Page 48.
Yes.
Lords, you turn to the second part. There are 2 parts of the book.
Second part.
That dirty color is there. First part is the white papers. No, that same book, my lord. Page 48. Yes, my lord.
14.
48. 48.
Yes, 48.
Not from the beginning, but lords, you can turn to the first part is there. The second, that book contains the second part. The second part starts after 112 of the first part. Lords, you turn to the first part is 112.
40?
48. Page 48.
Amendment.
That 3 is there.
Yes.
This is the 3. This is an provision for application attachment properties.
Yes.
Then they also turn to the right side. That the attachment here the application on receipt of the application. Then we'll also can turn to the 4 million. Any person agreed would file an objection. My learned friend.
I am not 3 million.
Let me. This is an objection. Then you'll also turn to page 52, my lords.
Further, my lord,
three questions. Ask 3 questions.
3 further.
3 questions. ମୁଁ ଆଗେ ଟିକେ କହିଦିଏ appeal ଟା କେମିତି ହବା କଥା. 3 ରେ attachment application was filed by the governments. Then under 4 lords, that 4 that he filed an objection. 4. Then lords turn to page 52, the appeals provision. Then any person who has shown cause that he has filed an objection, lord, made an application such that the court within 30 days may appeal to the High Court. This is settled, my lords. I verified. Lords.
Yes. And
now 3 day port do lords turn to the page 48 again.
Yes.
My learned senior relies on 3 an application under subsection 1 shall be accompanied by 1 or more affidavits stating the grounds on which the belief that the said person has committed any scheduled offense is founded. And the amount of money.
Why to get into, I'll convert it on your oral prayer.
My lord, my say, my restitute
He's
commission, my
not,
lord.
he's nowhere.
My lord, my
It
property.
is appeal lies. What I'll do is, I'll convert this to an appeal and to be on your oral prayer. On your oral prayer.
My lord.
Why to unnecessary?
My
lord. Petitioner has assigned the order dated. Where is that? Item
23/12/2023.
They order dated 153 page.
23/12/2023, my lord.
13, 13/12/2023.
Correct. 13/12/2023.
13/12/2023 passed by
The special judge.
by
Special judge vigilance.
Special Judge Vigilance
Cuttack.
in
Criminal
Miss Case number 9 of 2015,
Right.
whereby the application moved by the state
Under section 3.
3 of Criminal Law Amendment Ordinance 1944 has been allowed, and the properties of the petitioner has been attached.
The properties here were restrained from the alienating and
The order of attachment has been passed. Passed. Mr. Das and for the petitioner at the outset points out that
any order
against
under
the order, against the order
passed under
section 3
is
the-
available under section
the
11.
Petitioner ought to have filed a criminal appeal under section, what is that?
11,
Section
page 52.
11,
Page 52, 11.
under section
11.
Under section 11 of the ordinance 1944. At this stage, Mr. Mahapatra, legal counsel for the petitioner, makes an oral prayer to convert the revision petition to that of NAP. Accordingly, the oral prayer is allowed, and the registry is directed to renumber the
Nomenclature also be changed.
renumber the present case, changing the nomenclature accordingly, and thereafter, after renumbering the matter, release the matter before the assigned bench, subject to permission of the honorable chief
Listed
justice.
by Monday, my lord. I pray. Listed by Monday.
Sorry, sir.
I pray that matter been listed on Monday.
Subject to, it will go to chief
No,
justice.
the
Let it be Monday.
Some process is there. Let us
Next week.
Monday, there are 2 working days now. It can be done.
rest have number.
2 working days can be done. Yes, list of Monday. Because the sign could be. Take, yes. Yes.
27.
Yes, 27.
May I please already?
Yes, sir.
Initially, FIR was registered under section 498, 323, 313. And custody from 16/12/2023, my lord.
16/12/23.
Yes, my lord.
You are husband?
My lord, I am husband, my lord.
Yes.
Here, case initially with an allegation that in the year 2015, while the victim was going to the school,
It's 307.
30 subsequently converted to 498A, 323, 313, 307, 506, 34.
Where is the charge sheet? Charge sheet you have not filed. Charge sheet, what are the provisions?
First time it is coming.
Huh?
First time it is coming. 7 days time.
No. Is there any serious allegation? Just
Yes,
see.
yes,
What
yes.
are the allegations?
Yeah, 13 is there.
There-
13 is there, 307 is there.
AB
is also there.
AB is there.
498 bahaghara hela pare
CD call for, at least after 1.
Notice,
CD call for.
And
First
no-
time after CD police.
notice to inform.
Notice to, obviously.
AB is there.
extra copy.
Notice, you have implemented opposite party number 2. is
Yes,
there,
my lord, I have.
Issue notice to opposite party number 2. Yes.
My lord,
Call.
approve, my lord, extra copy. Or my lord? I'll
Give-
serve
give-
extra copy.
give- Yes, of course. These are the extra copy. Of course. Yes, next.
28.
After 2 weeks.
Extra copy.
Yeah, 28.
My lordship, on behalf of Mr. Sahu is not well. My lordship,
Urgent. On request urgent.
my lordship, 1 week after.
29.
Wait, pardon, madam. 27. I will serve extra copy. My senior to serve to the.
Give it to
Yes, ma'am.
give it. May I please yours? Madam, I am custody since 6/10/2021. 6/10. Yes, ma'am. Offense under section
6/10/2021?
Yes, ma'am.
Yes.
Offense under section 20B, clause 2, clause C, 25, 29 NDPS Act.
What is the recovery?
Recovery 261 kg गंजा में 261 kg.
261 kg.
My lord.
21.
Yes, ma'am.
Yes. What did he say?
Stage as per trial court advocate instruction, only charge frame is Saki ki chain.
The petitioner is in custody since 6/10/2021. The learned counsel for the petition submits that except charge, except the only charge has been framed till date, and the trial has not yet been commenced. Call for a report from the which court?
Jaipur, man.
Call for the report from so and so court. List the matter up to
Additional session judge
regarding the status of the trial and list the matter from. Yes. Read the judgment, Ravi Prakash. Read that judgment and come. I have called for a report. Okay. If the trial is not proceeding for a longer time, then a accused is entitled to bail. You are in custody since 2021. So it's about 3 years. So you may be entitled to bail. Therefore, I have called for a report from the court. Let us see what is happening. Okay. Read Ravi Prakash judgment and come. Yes. Next. Yes.
I may pardon to submit my lord. That offense is 419, 420, 467, 468, my lord, I filed a to release an interim bail because my mother is 75 years old lady and she is earning my lord. And my next.
You are in custody since?
Since my lord, 29/11/2023.
11/23. Let us see if you are entitled to regular bail. Why are you thinking of?
Direct that he will pay installment to the amount actually.
Yes, my lord. I am for the opposite party, my lord. They have
What
taken. He has taken 12,91,000.
12,91,000.
Was there any order for paying?
No, my lord.
No, already.
What are the offenses?
420.
419, 420, 467, 468, 471.
If you will stay, remain in jail, how will you pay?
But
Let him come out.
But that is my suggestion that he was. I was asking. My friend was saying I will pay 3 lakhs now. Yes, you pay some amount. I will court can.
Sir, you pay something, I'll
Yes.
Tuesday, shall I put it? Get some, let him see the color of the note.
Yes.
I'll give you regular bail, forget it. Interim. You get some money and pay him, I'll release you.
My lord, pay in court or what?
You bring a draft in his name.
Yes.
My lord, 2 lakhs.
3 lakhs.
I don't know, you have to satisfy.
He say more than that.
See, you try to.
He is custody now, 1 month. 8 months.
I know. See, you all try to be practical. If he is jail, you are not going to get anything.
Yes, my lord.
Okay. Whatever he is paying, take it. I am granting regular bail to him. Because these are not recovery proceedings, sir. I'll tell you, these are not recovery proceedings. He is entitled to bail. If whatever he is paying, take it 2, 3, 4 lakhs, whatever he is paying.
7 days.
These are not recovery proceedings.
Agreed for 3 lakhs, my lord. But my land.
Don't negotiate, you speak to him. He is a senior guy.
At the last occasion, he is ready to pay 3 lakhs.
Give 3 lakhs and allow you regular bail. See, these are not recovery proceedings. Try to
Yes,
understand.
yes, sir.
I
Yes,
will
sir,
not
sir.
write anything on the record. That
Yes,
how much is paid, why it is paid. See, these are documentary evidence.
Yes, my lord.
Charge sheet has been filed.
Yes,
He is in custody. He is entitled to bail.
Yes, my lord.
But once he comes out, he may not pay you anything. So therefore, I am putting it Tuesday. Whatever he is giving it, take it. Tuesday. That's the best way of doing it. Tuesday, you come with the money. Come with the money and pay him. I will allow the regular bail, sir. କିଛି ଧରିକି ଆସନ୍ତୁ ଦିଅନ୍ତୁ regular bail ନେବେ ଆପଣ 31.
31.
Obliged, my lord.
Yes. You speak to him, please. ଆପଣ ଟିକେ କଥା ହେଇଯାନ୍ତୁ। ନାଇଁ ଆପଣ ଟିକେ ବାହାରେ କଥା ହେଇଯାନ୍ତୁ। ବାହାରେ କଥା ହେଇଯାନ୍ତୁ, ବାହାରେ କଥା ହେଇଯାନ୍ତୁ। Next.
Please, Lordship. Lordship.
ବାହାରେ ଟିକେ କଥା ହନ୍ତୁ। Yes.
Lordship, I am appearing on behalf of my learned senior Mr. Milan Canongo. Lordship, on the previous occasion, Lordship had directed us to implead the informant as opposite party number 2. Lordship,
Already he has filed an interim
Lordship,
application.
I have filed an IA, which is a flag B for the same.
And that is the cheating by means of detaining of rupees 2 crores some or by means of digital way, my lord. That is
Oh, that's
QR score,
the one which you have shown me.
my lord. QR score scanner. It was.
Lordship, IA number 1085 of 2024.
Where have you implemented? You have not implemented.
Lordship, I filed an IA to implead the opposite
IA number
1085 of 2024.
1085
Lordship.
Is allowed, and petitioner is granted leave to implead. What is this name?
The informant as opposite.
Informant, one informant as opposite party number 2. Opposite party number 2. Let the petitioner file
Lordship,
amended memo of parties, issue notice to opposite party number 2, returnable after a week. Yes.
Lordship, may be permitted to file consolidated.
Yes, amended memo of parties means consolidated.
Lordship, he is in custody since 1 year. So kindly give a short date.
Short date, yes.
Date good, Lordship.
Initially, there is a case under section 307. After 3 days, my lord, the injured expired. It was converted to 302, my lord. And the parent petition in custody from 8/12/2023. Yeah, 23, my lord.
The rejection is on 26/12/2023.
You have the CD.
Yes.
Yes, I have given the tractate
for 20.
Yes, I have given copy to the my lord last time.
Why don't you go to the trial?
But that's why, my lord, last time my lord directed me because of the fact that I absolutely no allegation. I was not present in this spot, and as per the prosecution case, my lord, might be on me for a moment, my lord.
Why don't you give opportunity to trial court to also give bail?
The same thing will happen. With all respect, my lord, kindly appreciate, my lord, all, my lord, this, my lord will send it, all is a separate thing, my lord. But by the process, my lord, the multiplicity of the application will be arose in the honorable court, and besides, no purpose will solve, my lord. Not a single case.
No, larger purpose is solved. I'll tell you why.
Kindly appreciate.
No, I'll tell you. Leave about this case. Larger object is, if you give opportunity to the trial court to exercise, now the High Court is completely clogged because of the bail application. You have to encourage the trial court to grant bail.
My humble submission, my lord, not a single case where my lord has sent it. Is not a single case bail has been granted. Recently, my lord,
that is the cycle we have created.
No, that's up to because of the fact that I am before my lord has to decide the case. My lord is the master, my lord has to pass the order, my lord.
I will give a direction.
No, whatever, my lord, kindly appreciate. Whatever order will be passed by the court, 7 except rejection, nothing else will be happen. Recently, my lord, I was just talking Mr. Dol, my lord. Recently, 3-4 days back, my lord has disposed of case, giving him liberty, my lord. The same result. We have talked the same result. My lord, kindly appreciate because of the fact that once he is rejected, and once it has been, and my lord is disposing the particular case with some observation. What type of observation? That these are the things to be looked into. Even if they looked into, my lord, 7 except rejection, no further order will come. If my lord say, my lord, I have no other alternative, I have to. But see, that's why
I'm not saying that the High Court shouldn't consider. It shouldn't consider.
Oblige, my lord. And last time also,
you should give.
No, last time also, considering my submission, my lord has directed me to file charge sheet to examine.
Let us see.
It's a case, my lord, Messi, affair. What is the affair? FIR has been lodged by the none other than.
For antecedent there again. The petition.
Case
Well, come to the charge sheet.
First affair, madam. Affair, the allegation is that the father has lodged the affair, not against the petitioner, against the other persons, because those persons have assaulted by means of fist blows, slaps, and kicks. Fist blows, slaps, and kicks is the allegation as per the affair.
Right.
And my lord, thereafter, my lord, inquest report.
You have Vicky Patra.
Right. And thereafter, in the particular, the affair matter doesn't disclose my name. One thing, I take note of. And the particular injured was shifted to the hospital. After 3 days, he succumbed. And the inquest report, my lord. Inquest report doesn't also disclose my name. The inquest report disclosed that there was a tussle in the cricket field because of some previous dispute between the nearby neighbors, my lord. And there they have it is
eyewitness is there.
Yes, eyewitness is there.
Come to eyewitness.
Madam, directly, madam. I am taking madam. Moro namo E Donea. Such and such. ମୁଁ ଗୋପାଳପୁର କୋର୍ଟରେ କାମ କରେ ସବୁଦିନ ଭଳି 3/12/2023 ଦିନ ମୁଁ ମୋର ଡ୍ୟୁଟି କରିବା ପାଇଁ ଯାଉଥିଲି ହଠାତ୍ ହରିପୁର ଛକ ନିକଟରେ ପହଞ୍ଚି ଦେଖିଲି କିଛି ପିଲା ଝଗଡ଼ା ଲାଗୁଛନ୍ତି ସନ୍ଧ୍ୟା ପ୍ରାୟ 7ଟା ହେବ ପାଖକୁ ଯାଇ ଜଣା ପଡ଼ିଲା ଯେ ସେମାନେ ହଉଛନ୍ତି ଜନାପାଲି ଗ୍ରାମର ସଚେନ୍ସ ନଟ୍ ରିପିଟେସନ ସମସ୍ତେ ମିଶି ଦିଲେଶ୍ୱରକୁ ଗାଳିଗୁଲଜ କରି ଝଗଡ଼ା କରି ମଡ଼ାଙ୍କୁ ଆକ୍ରମଣ କରିଥିଲେ ଯାହାଫଳରେ ଦିଲେଶ୍ୱର ଚେତାଶୂନ୍ୟ ହୋଇ ତଳେ ପଡ଼ିଯାଇଥିଲା ମୁଁ ହଠାତ୍ ପାଖକୁ ଯାଇ ଛିଡ଼ା ହେଲି ଝଗଡ଼ା କରିବା ପାଇଁ ମନା କରିଥିଲି ତାପରେ ଦିଲେଶ୍ୱର ଘରକୁ ଖବର ଦେଲି ଏବଂ ଅଟୋ ଯୋଗେ ତାକୁ ବ୍ରହ୍ମପୁର ମେଡିକାଲ ନିଆଯାଇଥିଲା ସେଠାରେ ତାକୁ ଅବସ୍ଥା କରୁଥିବା ତାକୁ ଭୁବନେଶ୍ୱର ନିଆଗଲା ଗତ 6 ତାରିଖ ଦିନ ମରିଯାଇଥିଲା ଘଟଣା ଦିନ ଦିଲେଶ୍ୱର ଗୋପାଳପୁର ଖେଳ ଦେଖିବାକୁ ଯାଇଥିଲା ସେଇ ଖେଳ ଦେଖିବା ପାଇଁ କାଳିପାଳି ଗ୍ରାମର କଲ୍ୟାଣ ପିତା ସଚେନ୍ସ ଟିକୁ ପାତ୍ର ସହିତ ଝଗଡ଼ା ହେଉଥିଲା କିଛି ସମୟ ପରେ ମତେ ଦିଲେଶ୍ୱର ଫୋନ କରି କହିଲା ଯେ ତା ସହିତ ଝଗଡ଼ା କରୁଥିବା ବୋଲି ପରେ ଜଣା ପଡ଼ିଥିଲା ଏବଂ ସେଟା ଝଗଡ଼ା କରିବା ପରେ CH ଶେଖର ପାତ୍ର ନଟ୍ ପିଟିସନ ଲୋଚାପଡ଼ା ବିକି ପାତ୍ରକୁ ଫୋନ କରି କହିବାରୁ ବିକି ପାତ୍ର ତାଙ୍କ ଗ୍ରାମର ବୁଲି ପାତ୍ର ଜଗତ ସଚେନ୍ସକୁ ପଠାଇଥିଲା ହରିପୁର ଛକ ନିକଟରେ କାଳିପାଳି ଗ୍ରାମର କଲ୍ୟାଣୀ ପାତ୍ର ପିତା ସଚେନ୍ସ ଦିଲେଶ୍ୱର ପାତ୍ରକୁ ମାରିବା ନିମନ୍ତେ ଜଗି ଥିଲେ ହରିପୁର ଛକ ନିକଟରେ ଆଗରୁ ଜଗିଥିବା କାଲିପଳି ଗ୍ରାମର କଲ୍ୟାଣୀ ପାତ୍ର ନଟ୍ ପିଟିସନ ଚୌଧୁରୀ ଶିଖୁ ପାତ୍ର ନଟ୍ ପିଟିସନ ରାମପଲ୍ଲୀ ଗ୍ରାମର ଟିକୁ ପାତ୍ର ନଟ୍ ପିଟିସନ ବିକି ପଠାଇଥିବା ଲୋଚାପଡ଼ାର ବୁଲୁ ପାତ୍ର ଆସୁଛି ମୁଁ ଆଇ ଏମ୍ ପ୍ଲେସିଂ ଆଇ ନୋ ବିକି ପଠାଇଥିବା ଦିଲେଶ୍ୱର ପାତ୍ର ବିଧା ଗୋଇଠା ଚାପୁଡ଼ା ମାରିଲେ नो ऊपर नथिंग विधा गोईठा चापुड़ा मारले दिलेश्वर पात्र तले पड़गला ପରେ ତାର ମୁହଁକୁ ଗୋଇଠା ମାରିଲେ ଦିଲେଶ୍ୱର ପାତ୍ର ଅଚେତ ହୋଇ ପଡ଼ିଲା ତାର ମୁହଁରୁ ରକ୍ତ ବାହାରିଲା ଆସାମୀ ମାନେ ଲୋଚାପଡ଼ାର ବିକି ପାତ୍ରକୁ ଖବର ଦେଇ ତାଙ୍କୁ ପଳାଇଗଲେ ଆସାମୀ କଲ୍ୟାଣ ପାତ୍ର ସଚେନ୍ସ କୁ ଖବର ଲୁଚାଇ ଦେଇଥିଲା ଦିଲେଶ୍ୱର ପାତ୍ର ମୃତ୍ୟୁ ହେବାର ଖବର ପାଇ ଦିଲ୍ଲୀ ପାତ୍ର ସେମାନଙ୍କ ପଇସା ଦେଇ ବାହାରକୁ ପଡ଼ିଥିଲା ଝଗଡ଼ାର ପ୍ରଥମରୁ ଅବଗତ ଥିଲା ଏପରିକି ଦିଲେଶ୍ୱର ପାତ୍ର ବ୍ରହ୍ମପୁର ମେଡିକାଲରେ ଯାଇ ଚିକିତ୍ସା ନିମନ୍ତେ ବିକି ପାତ୍ର ଉପସ୍ଥିତ ଥିଲା ବିକି ପାତ୍ର
you have not only sent the people to attack but also you have after they came back and you kept it. That was the main
I have placed this statement wherein my name is there, I am conscious and ଦିଲେଶ୍ୱର ପାତ୍ର ସଚେନ୍ସ ଏବଂ ବିକି ପାତ୍ର ସେଠାରେ ଚିକିତ୍ସା କଲା ବେଳକୁ ଉପସ୍ଥିତ ଥିଲା ଏବଂ ମା ଭଉଣୀକୁ ସାହାଯ୍ୟ କରିବା ପାଇଁ ସ୍ୱାସ୍ଥ୍ୟ ବିଷୟରେ ଅନୁସନ୍ଧାନ କରୁଥିଲା so every malord take note of the entire allegation I was not present at the spot and the assault weapon of no weapon has been used malord the assault was made by hand at the kicks which is a part of the body nothing was there no intention
the communication was there he was making the communication
and nothing no weapon has been used and my intention and the allegedly the particular injured malord expired 3 days after malord and because of the fact that no weapon has been used and the 7 accepts
you are in custody since
6 months sorry I'm sorry 12 months I'm giving the number date malord 8/12 and charge sheet has been submitted
see what is in his favor is he was not in the spot and he has sent the people I don't know whether to kill or what but if he would have sent them to kill they would have come with arms and they came and gave fist blow and all eventually 307 and after 2 days they died. So therefore the intention part may be somewhere doubtful
because telephonic call
if there was yes if there was intention they would have come with weapon none of them were armed with any weapon only fist blow and all
the result
might not be having the intention to kill but
for that only this
ତାପରେ ବି ଯାଇକି ମେଡିକାଲ ବି ବୁଝାବୁଝି କରୁଥିଲା ଯେ ଭଲ ଅଛି କି ଭଲ ଅଛି ଚେଷ୍ଟା କରୁଥିଲା ଭଲ
October last night wait only 8/12/2023 wait for a month or so
September
I think October you will get bail
September last
I think you will get the bail yes next 33 yes sir
well, last time it was there not the offenses alleged that 419 420 461 and other allied 467 468 471 120 yes Lord let me last time Lord I was a little bit taken aback when Mr. Bhuya alleged that I am the kingpin but since I didn't my learned friend was absent and I had to borrow his file so I couldn't go so your lordship turns to page 20 Lord
20 of
charge sheet internal page 15 Lord of the charge sheet. What is this case is about Lord? Apart from the fact that 2 of the directors has already been granted bail, anticipatory bail Lord in this case, and their appeal in the Supreme Court has already been dismissed, which we got it yesterday
You are in
night.
custody since?
I am in 14/8/2020. 14/8/2020. My lord, see what is this? This is a very interesting.
What is, does he have flight risk? Flight risk?
Life risk.
No, flight risk he has. Does he have?
Flight
Flight risk.
पढ़े जाइपारे कि custody रो?
There is no flight risk. All documentary evidences. Do you need custodial interrogation?
Custodial is there. They have not applied as yet for custodial interrogation.
No, because we have already submitted the charge sheet. Charge sheet has submitted
Charge
as well.
sheet is submitted, yes.
11.
So custodial interrogation is ruled out.
No, ruled out.
And all documentary evidence. You tell me if he has flight risk or he can influence the witnesses and all.
If the company directors having 91% shares will not fly, then why should I fly?
Allegations are there. Serious allegations are there. I have seen it. Because he is the authorized signatory and he was working in some Chinese company and he is the bridge between the Chinese company and all.
Right.
Things are there. That is the reason specifically I am asking whether there is any flight risk involved.
That
You are investigating officer should tell.
yes. I have also come with.
And have you seized his passport and all?
Passport. No, passport has not been seized.
We will submit it before the IO. What is
You tell me that aspect. Shall I put it to Wednesday? Irrespective of allegation, these are the documentary transactions.
Absolutely correct.
And you have already investigated, filed the charge sheet.
Right.
Two of the directors of the company where he was working has already been enlarged on bail, anticipatory bail.
Right.
And the allegation against him is he is the person who is the authorized signatory.
Right.
And he was earlier working in a Chinese company.
No, that
Chinese company, and he is perhaps appears to be the bridge between the Chinese company and you, where the entire money has gone to that Chinese.
No, those two directors.
This is the allegation, serious allegation, no doubt about it. But detaining him in the jail for indefinite is neither here nor there, unless you make out a case that there is a flight risk involved and his passport and everything is there. Once he releases on bail, he will have a liaison with again that Chinese company and create hindrance in the trial and all. Unless you make out that case, I think he is entitled.
That instruction I will.
I think otherwise he is entitled to bail unless you make out that case. And if you make out that case, then it can be suitably conditioned.
Right.
It will be conditioned. You please assist on that.
The passport is not a problem. We will surrender it before the.
No.
That may be one of the
That
main
would be
conditions.
that a condition can be imposed to that extent, but he has to because see, and see, Indian money has gone to Chinese company.
No, it has not gone. That is what I wanted to tell me. Last
135 crores.
Last time, the astronomical figures doesn't match the case.
135 crores.
I will read the charge sheet. These two persons, those who are the directors, were also from 30-40 companies. My involvement, which according to the charge sheet, is with two companies, Byronite and Bepi. These are the two term company. Others are not concerned.
From these two companies, what is the amount transacted?
Millard, that I am placing the Millard.
Just let me.
These two companies, what is the amount
Millard
transacted?
Let me place Millard. What is the involvement, Millard? Of mine, Millard. Millard till 18/7, Millard.
Millard, Byronite, the only amount is 135 crores amount where he is the signature.
Only one company.
Millard, from only one company.
135.
135 crores amount.
The Lord, your Lordship will see these two directors were also previously working. That Chinese company was not that. China nationality, living in Bangalore, registered an Indian company, wherein it is alleged that these two of the directors, those who have been granted bail, and this person.
They were Chinese nationals. The directors were Chinese nationals?
No, Indians.
Indian.
They were previously working. Then that company was closed and he fled away. Because of some crimes reported in Hyderabad or something. Then she says that thereafter, again another company was formed and these persons were taken in that company. Those two are directors, 91%, and I am the authorized signatories. And what is the allegation, my lord? Allegation is, my lord, that we have traded in Bitcoin. That is, we along with Binek ID, my lord. My friend knows we are arguing another matter about Bitcoin, my lord, Bhadra case, wherein cryptocurrency, my lord, that it was found also that this Binke and others are the dealers, registered dealers in crypto coin. So, and already there is a Supreme Court decision that it is not illegal.
That's not illegal.
So,
why have you given this?
Say company memorandum ଦେଇଛନ୍ତି କିଛି ଦରକାର ନାହିଁ
that SLP.
SLP ଟା dismiss
Bail matter generally Supreme Court doesn't enter.
Bail matter never.
So that is
you just look into it, and I think he's entitled to bail because he is already in the custody for about a year.
More than
a year. Charge sheet has already been filed. But how many years you will keep him inside?
Till the trial is over. That is if I get
What is the stage of the trial?
Nothing.
Then far more reason that he should be granted bail. If the trial should proceed, at least we can wait. But trial is not proceeding. You have filed the charge sheet. He is there inside the custody.
You
I will come with that instruction or lordship.
Right.
Is in.
And you think over what would be the best condition suited to you, so that we will module that.
Thank God I am not pitted against Sangram. Otherwise, you would have come out with it.
Cryptocurrency also, I will be standing boldly.
Fantastic.
No, he is thinking of doing something and people telling him something against you.
I was a little bit shocked, and I don't like, this is not the manner in which government counsel should conduct himself. Sorry, Sangram. But he, in his anxiety, the petitioner counsel is telling that he will lose the job unless I get an interim order or something. Then he said, you must lose the job because you are a criminal. What is this? You are giving value judgment before the trial begins. Yes, Sangram has
Sir, the problem is sometimes they may say that we have learned everything from you.
No, that nobody will say. Mr. Bhuya was there along with me. He knows better.
See, that is the reason while arguing a matter, what kind of words you choose, that matters. That's very.
And I can say with pride that I am the only Advocate General that was considered wherever there is no case there. Justice Gopal Gaud asked me, well, this order may be set aside. Your person reads it, it is perfectly illegal. Then I said, well, Advocate General, why should we write concede, we will put it in other language. I told him.
That's right. The prosecutor doesn't mean that he is only assisting the court.
Yes.
He is not, opposing something. He is only assisting the court.
Then
if there is a bail, fairly one should say the bail. No
then
problem.
I told him, your lordship writes that I concede. the Advocate General concedes. Well, I am the Advocate General of the state, not of particular officers or department.
You're absolute. Absolute.
The criminal,
That should be the level.
the accused is also a citizen of the state. No?
Yes. You are supposed to protect them, being the state.
I am supposed to assist your lordship
That's right.
and defend the state.
Defend the state.
That's all.
If bail is made out, the prosecutor could simply say that, yes, grant me. And I've seen Mr. Raghunath does that.
March period.
It's all learning process. And from elders we learn things. Yes. Next.
34.
Yes, sir.
Yeah, the petition in custody since 14/7/2023, my lord.
14/7.
2023.
Okay.
Date of occurrence 13/7/2023.
What are the offense?
30234 IPC. Unknown affair. In course of investigation, the man accused arrested, while in police custody, he confessed to have committed the offense. The man
Confession.
Yes, and leading to discovery of the weapon of offense at the instance of that man accused.
Yes, except confession. What is
No,
it?
nothing there.
No.
Against him.
They both three persons, Jitu, Sibu, and Yerona, all these three first discussed that I have some difficulties with my wife. Then they plan what they shouldn't know. I have some. She has some illicit relation. Then okay, only will go for that.
Whose wife?
Sibu, the man.
Sibu's wife.
Man.
Had
Then-
some.
then
They
they
were having misunderstanding.
Then
And
they
this
went
Jitu is a friend of Sibu.
He took both of them in motorcycle. Jitu.
Then both Sibu and his
He
wife.
went there. They were first. They said that we will compromise with her. But in the meantime, the quarrel arose. So at a sudden that he was in backside, Sibu has taken that Kati.
My place.
That Kati, he thrice.
He was riding.
Yes, Sibu. And when they saw this, they enter into the house, and then the three return back.
What is attributed to him?
Him is only his friend, and he knows the everything what they made the plan.
Maybe.
That is directly he is not the.
Directly.
Yes.
Yes.
Yes, it was page 19.
19.
The second para. May I place it, madam?
Yes.
Charge it, yes. Apparent accused Milan Rona and Jitu Rona, and on being asked, Milan Rona confessed that
1 minute, let me read.
Yes.
Let me read that.
the deceased and one Milan, they were in love with each other. And Milan was staying at Chennai. He was working in a private farm.
1 minute, sir. Where
As
are
a lot.
What is this?
Page 19, madam. The second para, last portion, madam. Milan Rona and the deceased, Priya alias Sasadi Nag.
19.
Page 19, madam. Charge sheet of page 19, second para. Second para last. He also got it. Apprehended accused Milan Rona and Jitu Rona. He also got it, madam. Charge sheet of second para.
19 something else.
Yes.
I'm sorry, 20 madam. I'm sorry, madam.
Which?
It's apprehended accused Milan Rona and Jitu Rona on being asked.
I am not able to get where,
You'll also-
where are you? 19
Yes.
something else.
I'm sorry. You also,
That is-
you
that
also
is-
see that, my lord.
09.
It's
09.
Milan and the deceased.
During investigation.
Yes, my lord.
During investigation.
Yes,
what
madam.
was visited.
You'll also see the,
witness and-
you'll also have relevant portion I bring it to lordship notice.
Which part?
Is the last lordship.
Yes.
Apprehended accused Milan Rona
Hmm.
and Jitu Rona. On being asked, Milan Rona, he confessed that he committed murder of Priya Sesadrinak due to love affair. He stated that he has love affair with Priya Sesadrinak from last 2 years. They both well known to each other due to family relationship, but Milan suspected that Priya Sesadrinak might have relationship with others. So he started him. On the date of occurrence, all three came in a motorcycle. Sibu and Milan, they entered into the house. There was altercation between them. He told that, why don't you prefer to keep affairs with me? She said, refused. Out of certain protection, Milan and Sibu, they assaulted her. She died.
Yes.
Jitu was outside and he took both of them after that.
Where is the
occurrence.
statement? Show me. Show me. You are telling some story. He is telling some story.
No, my lord and friend.
Yeah,
is not.
treated him on the
Last paragraph, Lord. See.
7 accept the
Then
confession of
12 last
accused.
paragraph.
Nothing.
He not so to meet Priya and Shibu.
Again, I am placing it.
Where enter into the house of Priya. So now
So he decided, may I please, so he decided to take revenge from Priya as she cheated him on 13/7/2020 in the morning. He along with Sibu Rana, Jitu Rana came to Nikhil Nagar in a
1
motorcycle.
minute, refuse to
Yes.
keep love relations with him. On that, Milan become aggrieved and assaulted Priya also by means of suffered and her head and it to her. She fell down and then she there is nothing against him, Jitu Rana, in the charge sheet.
Let's see the conference statement, page 27.
Confessional, forget it. What he was outside, and
Yes.
these two people went inside.
Yeah, they want the
Sibu Rana and
Milan Rana.
Milan Rana. Milan Rana, and they have assaulted inside.
Yes, I told that both of them assaulted. He was outside after the occurrence. He took both of them in his motorcycle.
Right now, petitioner is accused in so and so, allegation against the petitioner and so on. After investigation, the charge sheet has been filed on
Charge sheet filed on 8/11/2023.
8/11/2023. And the investigation in the charge sheet, it is alleged. It will give the charge sheet go through. Apprehended. It will give the charge sheet. Apprehended. Apprehended to last year. From the perusal of the charge sheet, it indicates that it is the principal accused Sibu Rana and Milan Rana, those who have assaulted the deceased Priya. This is Priya, as a result of which she succumbed to the injuries. At the spot when the incident, the assault has taken place, admittedly the present petitioner was not present. However, immediately after the occurrence, it is the petitioner who has taken the principal accused in his motorcycle and escaped. The petitioner has been implicated in the case on the strength of the confessional statement of the principal accused Sibu Rana. Since having regard to the fact that there is no overtake attributed to the petitioner insofar as the assault to the deceased is concerned, and the fact that the petitioner against the petitioner only in the confessional statement of the principal accused is
Milan Rana
cited. Confessional statement of Sibu and Milan.
Yes,
is cited. I'm inclined to grant the petitioner on bail. Having regard to the fact that the petitioner is in custody since 14/7/23 and nature of acquisition and so on, so granted, and conditions, all these conditions are,
much
you shall appear and investigation is complete so that we are able to investigate cooperation and shall not influence and appear before the concerned IAC on
charge sheet file. You'll also court in session. You'll also direct to appear, or you'll also
appear before police.
Within a day or two.
Failure to appear on any date before the court for unreasonable cause shall entail the cancellation appeal.
Obligement.
35. May I please, Your Lordship?
Yes.
The 302 allegation against the petitioner, my lord. The petition is in custody since 16/4/23. 23.
Okay.
FIR is against unknown person, my lord. The petitioner arrested on the basis of the extrajudicial confessional statement of the main accused. There are three accused person, my lord.
Two of you have come, huh?
My lord.
Yes.
Another observer, it seems that
charge sheet has been filed.
Charge sheet filed.
When?
8/8/2023.
8/8/2023. Okay. You are appearing for
My lord, I'm appearing for informant.
informant.
Yes, my lord.
Yes.
From the one.
What is there?
Extrajudicial confession, my lord, last in.
Extrajudicial confession of the principal accused.
No, these two persons.
Okay.
Extrajudicial confession and last in jail, my lord. And what details, my lord? What details, from 8 to 9, and what details, number 1, and this reject.
Extrajudicial confession before?
Before 3 persons.
All the 3 witnesses
Yes,
are there.
they are there. And my lord, thereafter, after killing, my lord, what they had asserted on the head by the another accused, my lord. In the help of the 2 petitioners, my lord, they what they did, my lord, they got the private part and keep in their house. That has been recovered along with that act. From the main act.
Petition is accused and so and so, so and so. Charge after investigation, charge sheet has been filed. The 3 things have been imputed against the petitioner, namely the extrajudicial confession they have made before 3 independent witnesses. Second, since they were seen with the deceased lastly. Thirdly, the call records. Call records. It is also came on record that the nature of crime committed by the petitioner and the principal accused are very heinous. They have cut the private part of the petitioner and concealed the same, which has been recovered subsequently by the police. Having regard to the nature of accusation against the petitioner and the fact that there is a material available against the petitioner, I am not inclined to enlarge the petitioner on bail. Therefore, it is the bail application is rejected. However, liberty is granted to the petitioner to renew bail plea after the material witnesses are examined. Yes, next.
36.
Yes.
It's a corporation 6/2/2024.
6/2?
2024.
24, yes.
Offensive 420, 467, 130, happy for opinion, and also redoing 66 D of.
Charge sheet filed?
Yes, madam, charge sheet submitted. Charge sheet submitted on my lord. 4/6/2024.
4/6?
2024.
4/6/24. Okay. Your bail application rejected on
5/3/24. 5/3 charges.
Then you go to trial court. Go to the trial court. These are the offences you must get the bail. What is the bail? Let the trial court do it. Don't come to High Court for every.
Already costed.
Then you are redundant. You are making the trial court redundant.
Well,
If High Court will start doing this,
already
you have
costed
converted this.
10 months, my lord.
That's right.
That's not
Therefore,
time.
what I'll say is within 15 days your application will be decided. To that extent, I can help you. Right on. Petitioner is agreed by the order dated 5/3/2024, whereby his bail plea has been rejected. Subsequent thereto, on 4/6/2024, the police has filed the charge sheet after investigation. Therefore, I am not inclined to entertain the present petition. However, liberty is granted to present petition. However, liberty is granted to the petitioner to renew his bail plea before the trial court on the changing circumstances. Keeping in view of the fact that the petitioner is in custody since 6/2/2024, it would be expedient that the trial court should decide the bail application to be moved by the petitioner within 15 days from the date of moving such application. With this liberty, the petitioner is.
It was rejected during investigation. Last time I say during the investigation. In the meantime, charge is submitted.
The bail plea was rejected during the investigation, and subsequent thereto, the charge sheet has been filed.
And three cases similar type was also involved.
Don't create problem for you now. Yes.
38.
37.
Yes. Yes, sir.
Last time my learned friend wanted to show that there was a phone call by the deceased to her family members. And I disputed the same. I think we must have obtained instruction in the.
You have any?
No instruction is there.
It's a. I'm just granting bail, let him face. Let him face what? Right now, petitioner is making in so allegation of the petitioner is central. You read which, whose evidence is that?
All the evidence are similar, my lord.
Informants evidence.
That evidence, my lord, is the Sukanti Patra, sister-in-law of the petitioner, my lord.
But same similar line, huh?
Similar.
After investigation, charge sheet has been filed on
8/2/24
for alleged offence under section, punishable under section
498, 304B, 306.
Mr. Dhol, Learned Counsel for the Senior Counsel for the petitioner, has extensively read out the statements of witnesses recorded by the police under section 161 CRPC. And all the witnesses have deposed that the petitioner and the deceased married, had a law affair, and subsequently they married. And there was a disturbance in the family. On the date of incident, there was a quarrel between the petitioner and his wife. Out of anger, the wife of the petitioner hanged herself, and subsequent hanged herself. And after discovering the said fact, the witnesses have tried to rescue her. The petitioner is in custody since 14/10/2023. And what is the stage of the trial?
My lord, it has been committed to the Court of Session.
The committal proceeding, only the committal proceeding has taken place till date.
Additional Session Judge Atkar in ST case number 57.
And the
Now posting for the charge.
trial has not yet
Commenced.
commenced. Therefore, I am inclined to admit the petitioner to bail, subject to the further conditions, so on and so forth. He shall appear, and you should appear on every date of hearing.
Yes, but on the date fixed, but on each date fixed.
My name may be.
His name may be, and also by the Court of
Contrary,
Session.
he opposes the bail, stating that the marriage कितने दिन नहीं था?
5 months.
Within 5 months of marriage, the incident has taken place. Therefore, the offence under section 304B is also alleged against the petitioner. Against the petitioner.
Ballot to the satisfaction of the court in session or ballot in ST case number 4.
Court in session only, apparently. Yes. Yes, sir.
May I please? Petitioner, both the petitioner are in custody 6/2/23.
6/2/23.
23. Initially, case was registered 307. After 4 days of the occurrence, he succumbed, my lord. Allegation is that, my lord, one is 70 years, another is 32 years. Allegation is that, my lord, the brother of the informant is searching for his cow, my lord. He came while he was coming towards at that time, my lord, both the petitioner were there. There is a push and pull regarding cow. Thereafter, all on a sudden, the Basant Das gave a push, my lord.
Number two. Gave a
Push to the deceased, my lord. He fell down, and the head was contacted with the concrete road, my lord.
And died.
No, not died, my lord. Thereafter, my lord, the petition number 1, he has throwing a brick towards his chest. Thereafter, he taken to hospital.
Okay, I understood.
And 5 days after, he
Number of
succumbed.
eyewitnesses are there, my lord. The categorically stated what stated, my lord. Petition number 2 assaulted on the head, my lord. Assaulted head.
No, I'm thinking something else. What I'm thinking is, see, petition number 1 is 70 years.
Miller.
I'm enlarging human.
Miller.
And one you repeat. So
Miller.
50% you take.
Miller.
Take it. Right down. Petitioners are accused. Petition number 1 is 70 years age, 70-year-old man, and whereas petition number 2 is 32. The allegation of the petitioner is 32. It after investigation, charge sheet has already been filed.
Yes, ma'am.
It has come on record that it is the petitioner number 2 who had given a push to the victim, as a result of which the victim sustained head injury. Subsequently, the petitioner number 1 has thrown a brick
To the chest of the deceased.
Brick which hit the chest of the
Deceased.
victim. The victim was taken to the hospital and remained in the hospital for
4 days.
4 days.
4 days. 4 days.
Yes,
4
yes,
days,
4 days.
and subsequently he succumbed to the injuries. Therefore, the charge sheet is filed by the police for alleged offence under section 302
2/34
by 34 IPC. I am not inclined to enlarge the petition number 2
At this stage.
on bail at this stage because of his overtake, the victim sustained injury which led to the death of the victim. Death of the victim. However, taking into consideration the role attributable to the petitioner number 1 and the fact that the petitioner number 1 is a 70-year-old man, I am inclined to enlarge him on bail, accordingly, so conditions and yes.
Liberty is may be
Liberty
granted, my lord.
At this stage, I have said
Yes.
Obliged. At this stage, very particularly right now. Unnecessary, he will not be. Yes.
May plus. I filed my वकालतनामा
Sibo prisoner petition. Last occurrence was.
Prisoner petition?
Yes, ma'am.
Okay. What is the?
Yes, my lord. The victim is 10 years older than the petitioner. They were in relation since 10 years. It is stated by the informant as per the FIR under Annex 1.
October.
Oh, not Foxo, madam. She is 34 years.
Who?
The victim. The petitioner is 24 years old. The
Oh,
victim,
376.
the
Well,
victim
Foxo is not there.
not there.
Why are you
The
saying?
victim herself lodged the FIR, stating that there was relation since my lord 10 years.
Show me that.
Sir, I have an
What is
space
counting, my lord? Petitioner is a JE, my lord. Victim is a doctor. Admitted last 9 years, the relationship, my lord. Get physical relationship last 9 years. Subsequently denied to marry, my lord. Thereafter, victim lost his FIR, my lord. And, my lord.
Grant me.
Sure.
Write down. Petitioner is accused in so and so case. Allegation against the petitioner is so and so. Petitioner is a 24-year-old man working as
JE. Junior
engineer.
my lord.
Whereas the victim
Doctor.
is a 34-year-old
Doctor.
lady who is employed as a doctor.
My lord.
Admittedly, there is they were in relationship for about 9 years.
9 years.
Since the petitioner has refused to marry the petitioner victim, she has filed this present FIR. Petitioner is in custody since
9 to 2024.
9 to
2024.
23.
24.
2024. Regarding head to the nature of acquisition and period of custody, granting bail.
My name may be reflected. I filed Wakalatama in registry.
But he is a junior engineer. Why jail petition?
से ये लास्ट वीक रे थिला से 4 जन को एंगेज करिया पे लिखिथिला 4 जन को वकील ना सिंस आई वाज प्रेजेंट हियर योर लॉर्डशिप
Okay.
माय नेम सूर्यकांत आई फाइल्ड वकालतनामा इन
File and take it.
Yes.
Some condition may impose, so the men threatened, my lord.
Oh, the same normal condition. He will not be in contact with the
Yeah,
lady and all.
that way.
Now, if you say this, he should not be in the contact of the lady, they may marry also. Why do you prevent? वो condition मत लगाना. You are preventing them to marry. So let them marry. Yes. 41. Don't put that condition, huh? They will not be in contact. Let them be in contact.
My lord.
Right. 42.
In this
Yes,
case,
yes.
the accused petitioner is in custody since
Yes.
8/1/2024.
Huh?
8 January 2024 on an allegation on section 376 2N. The age of the victim lady is 36 years and the accused is 42 years old now.
They were in relationship.
They were in relationship. The victim has already.
No. What I'm from delayed victim age 164, stated 27 years, my lord. Petitioner is a married man. Get relationship for a long time. In the meantime, they get a child, my lord. Thereafter denied to accept, my lord.
No, that's right. But they were in relationship.
Yes, he gave birth a child, male child, my lord.
That's right. But she was an adult, and she must be knowing what is the consequence.
What is the consequence of petitioner? He's a married man, and he is.
She show me the relationship. They were in relationship or not. If they were in relationship, it's a consensual thing.
She has also.
At 27 years, you should have known
And
what is she doing.
charge sheet file after the registration order, my lord.
Oh, that is there. But
He gave a file.
we read the 164.
My lord.
She is 27 years old lady. She should know what is the
से
consequence.
आगुरु विवाहित से प्राय 4 वर्ष विवाह करथिला.
Then काहे relation रोकतला?
More than I said. That is not my case.
You know everything, and that lady was trying to spoil the life of that other woman.
My lord.
My life, my lord.
Both of them should be there in the jail.
My lord, my learned friend is focusing in another case. That is not my case. My case is different. The victim is a married lady having 3 children. The accused is also a married man. My learned friend might have another case.
41.
No, this is voodoo.
PLAPL 2929.
2929. 2873. Sorry.
You don't bring some other fact.
Sorry, my lord. Sorry.
Yes, read voodoo.
My lord, the victim, the trial court was directed to examine the victim. Meanwhile, the victim lady has been already examined. The deposition of the victim lady is annexed as flag K.
Yes, my lord, yes.
Yes,
29,
1 minute, let us see.
Yes, 29. Can I have a last order of this one, 19/7/24, my lord.
Yes.
Then mentioned in view of such matter, director, victim be examined as first witness from the
He
prosecution.
has already been examined. That's what he
That,
said. Where is that copy?
I have already, the
Yes,
letter trial
deposition
court
is
has
there.
already sent.
1 minute, what
Yes.
he says. Deposition. A 36-year-old.
In the cross examination, maybe kindly peruse, my lord.
You read it out. Cross examination. What?
The victim lady has specifically stated, I am reading the relevant points. The accused was calling me to his house over telephone. I was visiting his house during midnight. The court may please to see, before leaving my house, I was not intimating the fact of my family members. My mother's house intervenes between my matrimonial home and the house of the accused. On the day of occurrence, I was staying in my mother's house. The accused happens to be my brother-in-law, husband of my elder sister. We had cordial relationship with the family of the accused. Prior to making the recording viral, there was no inimical relation with the accused. I had never.
Right up. Right up. Petitioner is accused in so and so case. The victim is a 36-year-old lady, whereas the petitioner is
42.
42 years old man. And when the matter was taken up in the large data hearing, this court has directed that the statement of the victim shall be recorded preferentially. Subsequent thereto on
16th August.
Subsequent thereto, this is yes, subsequent thereto, the statement of the victim has been recorded on
16th August.
1/8/2024. 16/8/2024. And the state statement has been transmitted to this court by the learned additional district sessions judge, FTSC, Jaipur, Koraput. In the cross-examination, the witness, the victim being PW1 inter alia has stated as under para 3 written. Para 3 of the cross-examination. Para 3 of the proceedings. Regarding head to the nature of allegation made against the petitioner and the fact that the victim has already been examined and who in her statement inter alia stated that they were in a relationship when she was frequenting to the house of the petitioner in the midnight without informing her family members. I am inclined to enlarge the petitioner bail. The petitioner is in custody since 8/1/2024. Granted bail. Yes.
Obliged, my lord.
Yeah.
43.
May I please, Your Lordship?
Yes, madam.
Your Lordship, I may be allowed to appear virtually, Your Lordship.
Yes, yes.
Your Lordship, both the petitioners have been in custody since 22/7/2021, charged under section 30234, Your Lordship.
22/7?
2021.
21/7/21.
Yeah. What are the allegations?
Allegation of father and second wife brutally killed his son, my lord. His son opposed to his second marriage, my lord. And he has son sustained 11 injury in his persons, my lord. This is case. Total 3 witnesses are there, yet to be examined, my lord. 3 witnesses are yet to be examined.
Wait till eyewitnesses are examined.
My lord.
Okay. I'll just write down. The petitioner is accused, petitioners are accused of so. Allegations are serious in nature. There are 3 eyewitnesses to the occurrence. I am not inclined to admit the petitioners on bail at this stage. However, liberty is granted to the petitioner to renew the bail application after the eyewitnesses are examined. And with this liberty, the petitioner is disposed of. Yes.
44.
Please, your lordship.
Again,
The last occasion.
373, CD ଟା ଆଜ୍ଞା ଆସିନି।
CD ଆସିଥିଲା।
ନାଇଁ,
But last occasion, my lord was directed to file the deposition copy of the witnesses.
Have you filed it?
No, just today I received the certified copy of
You
the.
do one thing, you file it and
My lord,
give a copy to him.
my lord.
And I'll list it next week.
My lord.
Okay,
My lord.
list
I am
it next
for,
week, let
I am for the
council repeat it.
informant. Copy another. I am for the informant.
You also take it.
Item 58 matter. Yesterday I have received the counter matter, so I have to file the agenda matter. What is the item of 58? Because one of my matters is number one.
You must go there, no problem, but interim order is there.
Item order.
So why rejoinder? What kind of, what is this petition?
It is a domestic violence.
See, what I'll do is, I'll adjourn it, no problem, you file whatever, but no 4 weeks.
Jurisdiction टाକୁ challenge କରୁଛନ୍ତି and I am unable to pursue the for maintenance.
I what pleading in so these guys?
DV Act ଟା ଖାଲି ଆପଣ ଖାଲି କହିଥିଲେ counter ଟା ମୁଁ file କରିଛି jurisdiction ଟା they have already challenged. ଆଉ ସେ କହୁଛନ୍ତି ଭଦ୍ରକରେ ହେଇପାରିବନି statute says temporary reside ଯୋଉଠି ହେଲେ
Take
ହେବ.
after 2 weeks, huh? Exact after 2 weeks.
Date may be fixed.
Date will be fixed, yes. On the request of the counsel for the petitioner to file rejoinder. Rejoinder to be filed within 1 week. If within 1 week rejoinder is not placed on record, right to file rejoinder is shall be stand closed. Lease the matter up. Yes.
Mr. Maharaj Maharaj watching the proceeding matter today. Last half an hour.
And he is watching to complain subsequently. Okay.
Outlet should.
12. 44? Pass over. Yes.
Item 12.
Yes. Yes. Are they appearing?
Yes.
The three parties.
Sir, no.
Yes. Sai Prasad Tripathi. Where is the informant? Nivedita?
By mistake, they have appeared in court number 16. They're just logging. Appear.
They have separated.
Filing the certified copy of
And
the
Nivedita, can you hear me? Do you have any objection if I pass the entire criminal case against against Sai Prasad and other family members?
No, sir, no.
No objection? You have settled your disputes?
Yes, sir.
You got your permanent alimony?
Yes, sir, I agree.
How much?
1,000.
12 lakh
12 lakh.
12 lakh 50,000.
Right now. At the instance of opposite party number 2, FIR number so and so came to be registered against the petitioner. The petitioners, allegation against the petitioners are certain, sir. Parties have charge sheet has been filed.
Yes, yes, ma'am.
After investigation, charge sheet has already been filed. The dispute is primarily arising out of matrimonial discord, while the matter was at the stage of trial. The parties have settled their dispute. The petitioner number 1 and opposite party number 2 filed. This is contesting. Filed an application under section 13B of Hindu Marriage Act, dissolution of marriage. The family judge Jagat Singh by its judgment dated 10/4/2024 in civil proceeding number 45 of 2024 has allowed the prayer and dissolved the marriage between the petitioner number 1 and opposite party number 2. In lieu of the the divorce, the opposite party number 2 has been awarded rupees 12,50,000 as permanent alimony. Permanent alimony. The petitioner has already paid the said alimony. In these under the terms of settlement, and the parties have agreed that all the dispute amongst themselves against each other shall be terminated. On the basis of the same, the present petition has been filed. Have you filed affidavit? Huh?
Joint affidavit I have not.
Petition number 1?
Joint affidavit petition has been
Joint affidavit filed.
13B. 13B petition has been filed, which is
Okay. The parties had filed a joint affidavit before the trial court at the time of hearing in the application under section 13B of Hindu Marriage Act, and they are relying upon the said joint affidavit. The petitioner number 1 and opposite party number 2 are present in the court, being represented by the respective counsel and identified by them, and they have also filed their self-attested copies of Aadhaar card, which is to establish their identity, which are taken on record. Insofar as the petition number 2, 3, 4 are concerned, although they are not, they are the parent in-law of opposite party number 2 and sister-in-law, brother-in-law of opposite party number 2. Although they are not present, but they are being represented by their counsel. And from the query, the VC appears through VC. To the query by the court, the opposite party number 2 has stated that the marriage between her and the petitioner number 1 has already been dissolved by the judgment dated for 10/4/2024, and she has already received the permanent alimony of rupees 12,50,000 rupees. He doesn't have any objection if the proceeding is dropped against all the petitioners. Regarding head to the aforementioned development and the law laid down by the Supreme Court in Guarantee, subjecting the petitioner to exercise.
Second case, husband and file against wife.
Second case, what is this? This FIR is?
The complaint case, my lord. Complaint case.
At the instance of
not be initiated.
second case, 788. At the instance of the opposite party number 2, the husband, the complaint case has been initiated. Complaint case 1, complaint case being ICC number, ICC case number 4430 of 2021 has been initiated against the petitioner number 1 and her family members. Petitioner number 1, wife and her family members. In the parties have settled their dispute. Insofar as the criminal case initiated against the opposite party and his family members, at the instance of petitioner number 1 is concerned, the same has already been quashed while allowing CRLMC number 754 of 2024. In view of the order passed today in CRLMC number 754 of 2024, the present proceeding is also, the present petition is also allowed. Accordingly, the ICC case number 4430 so and so pending before so and so also stands quashed. Yes. Dispose of both the matters. Yes.
47.
245. May I please? 245. 40?
47.
Yes, sir.
Initially, the case was registered 302 and 34 IPC, where the petitioner the deceased related to each other. In absence of the petitioner in the house, the deceased committed suicide. by means of hanging.
Charge sheet file?
Charge sheet file, Lordship. I also annex all the materials,
306.
306, Lordship.
Custody since?
Custody, no, Lordship. I was washing the.
Achha, quashing.
Lordship.
Okay. Quashing to not possible.
It is a matter of 306.
No, here, Lordship,
And
Lordship, on the last occasion, Lordship issue notice to the OP, Lordship.
Oh, service is complete.
Service noting is there, service is completed, Lordship.
So let us on 7/8/2024, notice to the opposite party number 2 was issued. Despite completion of service, none appears for the opposite party number 2. In the interest of justice, urgent to good a week for the year. Good opportunity deva.
No coercive action. Prisoner lady, Lordship. No coercive action till then. ଗୋଟେ ସପ୍ତାହ ପାଇଁ no coercive.
Anticipatory bail is rejected.
No. Anticipatory bail ନାହିଁ.
She is a lady.
Lady, Lordship.
She how she
But he is related. The disease how ଶଳା ଭାଉଜ ଆଉ
matter of my lord, but
they have
case number.
Trial also the case is not even committed.
My lord, this is the matter of 2022, my lord.
Charge sheet has been filed.
Charge sheet is submitted.
What is coercive action?
No coercive action.
Till then, only for a period of 1 week, Lordship.
What will happen?
No
2022 charge sheet is filed, you are not arrested. No process is used, issued, nothing.
No, only no coercive action.
Once you have passed no coercive, then it
last occasion, Lordship also told without giving.
1 week after you come and argue.
On the last occasion, Lordship also directed to the opportunity given to the informant. Thereafter, the interim order may be passed. For that reason, I am requesting to no coercive action.
If the trial is not commenced, why you are not being arrested? Summons are not issued to you. Nothing. You show me
ଗୋଟେ
something.
ସପ୍ତାହ ପାଇଁ ଖାଲି ଥାଉ.
Why unnecessary?
Lady, Lordship, the two kids are there, Lordship.
Lady is there, it's all right. You move application, I'll say that before trial court if summons are issued.
Lordship.
If the trial liberty is granted to the petitioner to move appropriate application before the court seeking an adjournment in the event the trial starts independently. Yes. Okay. But don't ask for adjournment. I'll vacate it.
No. I will pardon to mention, my lord. Item 46. I did not adjourn that matter.
Mr. Marana is not well. Yes.
48.
Yes, sir.
This case relates to Drugs and Cosmetics Act, but the action has been taken under IPC even though the seizure was made under the Drugs and Cosmetics Act. That is the first thing. The second issue which is involved is so far as the discharge, while framing the charges, the petitioner asked for certain time to file the discharge application because the police paper was handed over on the same day and the charges were framed. So that opportunity was not given also to the petitioner. So these are the two basic grounds on which we have filed the application. I was requesting my learned friend because Mr. Das, who is the briefing counsel, actually he has broken his leg. He had a fracture. So if
there is an interim arrangement,
yes, that can be
continue.
Yes.
Least it after 2 weeks. The interim arrangement made on 17/5/2024 shall continue.
My lord, your lords fix it after 15.
After 15.
After 16.
May I please, your lordship? My lordship, on behalf of Mr. Deepak Ranjan Sundar Rai, he is not well, my lordship. I am seeking an adjournment.
You should have read it. What is the problem? You should have read the brief.
My lordship, but actually I am not advocate on that case, my lordship.
You could have called for the file and read it. Okay. Next.
50.
50.
I am for the petitioner, my lord. The last occasion, lordship, you should know.
49 you are.
My lord, I am appearing for private opposite party, my lord. I mean, to appear through BC, my lord.
My lord, in item number 49, copy has not been served, my lord.
So, yes.
And 50.
Opposite party number 2, you are appearing?
My lord, I am appearing, my lord.
Yes.
Lordship may adjourn this matter.
Yes.
But final hearing, Lordship may adjourn this matter. Small issue involved in absence of a company in a criminal case, whether such proceeding can continue or not.
This is 138.
No, my lord.
Questioning of cognizance. Offense
under
under 447
506.
Okay. Charge sheet filed, huh?
Charge sheet filed.
Cognizance is taken.
Cognizance is taken.
What in absence of?
Here, my lord, the petitioner is the managing director of a company. Now the company is running a petrol pump in the name of in that land. They are alleging that we have trespassed their land and constructed the petrol pump. Now,
Company will never trespass.
That, my lord.
Dealer.
Company doesn't have legs to enter into somebody's land.
My lord, if
You are the managing director, you have done in the name of company, you went trespass.
My
So
lord,
what is the
because
company is not necessary.
here,
But
my lord, here company is necessary.
why? Tell me, show me. Show me the law.
My lord, also may see the FIR, please tell me. The land I issue such and such. I beg to inform you that the land details which they have given have been recorded in the name of my father. That one Srinivas Sahu, the managing director of MS Trackers India Alloys Limited, has installed a retail petrol pump under Reliance Industries, has forcefully trespassed into my land recorded in the name of my father illegally. This came to our notice on 23.
He has trespassed and using it as a petrol pump.
My lord.
My
lord, here the company is running the petrol pump. My plea is that since company is running the petrol pump, without adding the company as an accused, this proceeding cannot.
Then you will be acquitted. Why do you worry? You will be acquitted.
My lord.
You will be definitely acquitted. Go and face it.
My lord,
That can't be a ground for quashing.
Lordship may fix that next to that.
That's better idea. That's better idea. He's asking for an adjournment.
My lord.
He's not prepared. Okay.
My lord.
After 1 week. Prepare properly and come. Don't take the risk of doing. Yes.
51 minutes. I'm appearing in the VC mode because of the broken planes. I'm challenging here in the Annexure 5.
You are with a broken leg. Why are you arguing? I'm simply adjourning. Okay. Get well.
Lordship, there's one development why I wanted to bring before Lordships. This is actually interstate dispute between two neighbors pertaining to parking space. So if they can be referred to mediation for.
Have I issued notice?
No, notice is not issued.
What are the offenses? Alleged offenses?
506 minutes. 506. The first FIR was lodged by me. I mean the two petitioners, which is an Annexure 6.
Copy note, sir.
Counterblast.
But he says that between neighbors arising out of a parking issue.
Yes.
I'll issue notice and refer it to mediation.
Yes.
That's a better idea. Right on.
Yes.
Issue notice to opposite party number 2. Retainable notes. Land Counsel for Mr. Das, Land Counsel for the petitioner submit that the dispute is essentially arising out of a parking issue. There are cross cases. There are cross cases filed by the petitioner and opposite party number 2 against each other. Therefore, he submits that there is a scope of settlement in the dispute. In that view of the matter, the parties are relegated to. You are from Cuttack?
We are from Cuttack.
Parties are relegated to High Court Mediation Center.
Both are from Chowla Cuttack.
High Court Mediation Center, and the coordinator of Mediation Center is directed to fix a date for exploring the possibility of settlement. And after the mediation, a report should be submitted before this court on the next date of hearing. The counsel for the petitioner is also directed to serve the copy of the present order to the opposite party number 2. After 3 weeks of your
Lordship, I am appearing virtually in this matter, item 52. And I'm praying for quashing. And the complainant here is opposite party number 2. And the affair was given against 4 persons. Petitioner number 1, 2 and 2 other persons who were exonerated while filing charge sheet because they were not there in the scene. And offenses are, I am implicated under 294 and 56. There is not even a single iota of criminal ingredients to be trialed for me to face the trial. And in fact, the complainant is my brother. He has clearly mentioned in the FIR that all this dispute is happened because of property. And there is nothing mentioned in the FIR. My lord, may I go to page.
What are the offences against you?
506 and 294. FIR was registered.
You are the brother.
Yes.
Same order. Issue notice. Go to mediation. Same order. Go to mediation. Settle it. You people are brothers.
Those brothers.
But Lordship, what shall I say?
In his absent, another brother has given rent.
Issue notice to opposite party. 1 minute. You have to settle the dispute.
Yeah, I am ready to settle. But what shall I settle, Lordship? But because the civil dispute is pending there.
Then I'll do one thing. I'll dismiss it and go and sort it out there in trial. Okay.
Lordship, I may refer it to mediation, Lordship.
No, then I'll dismiss. If you have such a high ego, that
No,
why should
I don't have any ego. In fact, I am asking him.
You are fighting with your brother. I am suggesting that
Lordship,
settle it. Why should I settle? What is this?
Lordship, kindly hear me on merit. Lordship, in fact, the affair.
No, I will not hear on merit. This is not a case to interfere. I'll dismiss it and go and fight it out in the trial. Okay.
Lordship, I disposed it, Lordship.
I'll not interfere. I'll dispose it. Okay. I'll dismiss it. And you will be in serious trouble thereafter.
Lordship,
on merit, I'll have to observe something. You will be in trouble.
Lordship.
Coming at the threshold, your informant is your brother. I am saying I am issuing notice.
Yes.
Sending to mediation.
Okay, Lordship, that can be done. Lordship, that can be done. I could not hear that the Lordship is issuing notice, Lordship. I could not hear.
So have patience, and while arguing in the court, see the mood of the court, and don't try to be smart. Then you will be in trouble.
Lordship, I will take care.
Yes. These are the arts you have to learn.
Lordship.
And if you want relief, if the court is giving, take relief installmentally.
Lord.
Don't think that in one day everything will be passed, you will be free. Slowly you take the relief. Okay. Same order. Mediation cell potato. And you the order which I am passing today, take a copy of that and give it to your brother.
Lordship, I will do it.
Who is the informant? Okay.
Lordship.
And advise your client to suppress the ego and participate in the mediation process.
Lordship, affair was given in 4 names. In charge sheet, only 2 names were there. And my 2 sons were exonerated by the IU because we were not. This affair itself is false.
You are very much interested to fight out the case.
I am. I just want.
Yes, next.
53. May I please, Your Lordship? My Lordship, on behalf of Mr.
These people don't understand. Yes.
Perhaps the party is present with him. For that
and spoil the case there. Yes.
My lord, item number 53, my lord, as per noting, notice could not be issued to the OP2 and 3 due to the incomplete filing of requisite.
My Lordship, actually, though the requisite are filed, but we don't have the AD actually. Unavailable of AD, that's why we.
Adequate.
My Lordship, we submitted a postcard.
Do it once again. Do it once. Oh, sir is waiting. Ask him because I'll get up to him. Which matter? Next item.
Obliged.
54. Yes, madam.
Your Lordship.
Hmm?
Your Lordship,
Somebody asked for the adjournment.
Your Lordship, I'm seeking adjournment of 2 weeks.
Somebody asked. Yes.
Item 54. Well, can it be fixed for a short date? Because here the problem is that the wife of the accused is dead in the meantime. He was a medical officer in a CHC, community health center, my lords. Now that he has been terminated from his service because of the conviction, they are not getting any pensionary benefits for that reason.
Consequence what?
My lords, they are
harsh, but But we'll see how can we adjust. And
Yes,
give
my
it.
lords. Because on the last occasion also the counsel for the other side did not appear.
Why are you not interested to argue? Don't have a good case.
No, Your Lordship, we do, but my senior.
Get
Mr.
ready.
Daylight-
Next time I will not adjourn.
Your Lordship-
Or at the request of learned counsel for you are in first matter or second matter?
Your Lordship, is for Bholanath Raut. Bholanath Raut.
I'm in the first matter. He's in the second matter. The second
Counsel for the petitioner, urgent to so and so, it is made clear that no further adjournment shall be given.
Appellant पे मतलब से मैंने second sub item. If your lordship permits me, मैंने first sub item I'm ready to argue.
No, not piecemeal. Not piecemeal.
Yes.
Not, yes.
55. Oh, bless you.
Great.
May I please, your lordship?
Yes, sir.
And before going to the matter, I will say my young friends are here. They must follow the mind of the court.
That's what
the
I was-
court intend to propose. And I was hearing that gentleman.
Young boy is trying to. That is what the important thing is. The youngsters should sit in the court, understand how things are moving.
Okay.
Where to stop, where not to speak. That is very important.
My
Yes,
lord,
sir,
so
yes.
far this matter is concerned, I will give the ball to my friend's court. He is the leader of the bar, Mr. Vijay. Regarding the
What happened in this case, my lord? The petitioner and advocate of this bar, my lord. Allegation 376, my lord. My senior, my lord, is appearing, my lord, for the
Quashing.
And both will.
You are not
informal. Opposite fact now.
She has filed affidavit that matter has been settled and she
In
is
the last occasion, you used to be ask them to appear and file joint affidavit. For that reason, case adjourned.
Settle.
If you will go to law, my lord.
No, law.
No,
I'm not opening.
I frankly say that if you will adjudicate it by keeping mind the judgment and law,
Then no.
then there is no chance. It is true.
I'm not looking at the file at all. Very sick. Can she come?
Yes.
Letter appear through VC.
Yes.
And both of them let them appear.
Exactly.
through VC. And without writing much about anything.
Simply today, your lordship adjourned the matter on request and non-officially he is supposed to bring that.
And don't.
Bisire.
Bisire better.
Exactly.
Why after calling that woman?
Why? Why?
Both of them.
Tuesday,
Both of them.
Wednesday, whenever you say.
Yes.
You tell because he will come because he is in a suit.
I will inform the court master.
Sir is coming here, my lord, much more reluctant.
What to do?
Since advocate involved for that, sir is coming, my lord.
Now, sometimes we are being compelled to
And he's
appear.
a young man. He's young
Exactly,
man.
exactly.
His life will be doing. And
The
follow. Tuesday, Wednesday.
2 minutes I will inform.
You ask and intimate him
court
so that he'll fix
Please
it
do.
and tell sir also. So that
Yes,
he
yes,
will
yes.
also- Okay. But the request.
My lord, before parting, may I request one thing?
Yes.
I have another matter that is a vigilance matter. Appeal is there. 'Cause I have gone through the record. I want that I will go through the statement recorded on section 113. What the explanation? That was not in my file. So this week the matter may be adjourned to the next week. In the main period, I will go through.
Okay.
Kete number?
Which items?
21. Weekly list.
Let it be there. You come and take in pen drive and give it to sir. He'll read it. Okay. Let it be there. I'll accommodate when it comes. I think we stop here. Anything? Mr. Mahapatra, Vivekanand Mahapatra is there.
Yes, Lord, in the first hour, my Lord, Miss Mahapatra sought for adjournment. But that is the reason because he has.
Okay, 56. 56. Urgent. Yes.
Interim order may be continued.
Interim.
Interim.
The rest of the matter you can Rollover, yes. Entry model to continue. I think we can roll over all these matters for Monday. Roll over. 4 to 5 minutes. 4 to 5. Include it in the Monday list. Monday list. 57 towards 57 onwards.
57 what happened, my lord? Both are fighting here, my lord, but the police submitted final report.
Alright.
I was supposed to be, my lord, I was supposed to be give a the Supreme Court judgment, my lord. But it is better, my lord, my
now.
senior government counsel has reflected and stated before this court.
I'll
that
just simply say this you have filed for quashing of what?
Washing up
FIR,
my lord.
And proceeding.
Right.
And this
petitioner has invoked the inherent jurisdiction of this court under 482 CRPC, seeking quashing of the FIR and consequential proceeding arising therefrom. In the meantime, after investigation, the police has submitted final reports.
Insufficient of evidence.
Due to insufficiency of evidence.
Yes. On 16/7/2024.
On 16/7/2024.
24.
In view of the aforementioned development, nothing survives in this matter. Accordingly, this decision.
My lord, item 60. Last occasion, my lord directed to the petitioner deposit the loan, hand loan amount. That is 70,000. Already deposited, my lord. This is the issue.
Who is appearing?
ସେଥିରେ କହିଥିଲେ ଦେଇଦେଲା ପରେ କ୍ୱାସ୍ କରିଦେବେ ବୋଲି କହିଥିଲେ already deposit.
Who is opposing you?
Opposite notice ଯାଇଥିଲା appear କରି ଯାଇଥିଲେ ବି ମଧ୍ୟ. Opposite notice ଯାଇଥିଲା appear କରିଛନ୍ତି. Some Agrawal.
Just see here who this display board. Just see. Offense?
Offense, my lord, converted to 166 converted to GR. 323, 324, 355, 417, 500, 294 and 120B. Hand loan
60. Anybody?
Arising out of complaint case. Complaint.
So, let it be there on Monday. I'll take it to Monday. Monday, huh?
Item 62. Already the lower court can dispose of. I am for the opposite party. If the petitioner will there, then it can be
dispose of what?
The main case disposed of. In the meantime, ended with conviction.
He is seeking what?
My lord, he is seeking for with a prayer to examine the PW, my lord. The witness, defense witness.
Oh, conviction has
my lord, in the meantime, conviction still.
62?
62, man.
Just 1 minute. 62 likho.
I am for the opposite party.
Petitioner is agreed by the order dated 27/9/2023 passed by JMFCT Barampur, Ganjam in ICC case number 356 of 2023, whereby his application for
138. 138.
What was it? The order dated?
Order 29/9.
What was that order?
That is the order, my lord. He prayed for, my lord. That is rejected by the London court below.
I know what was the prayer.
For examination of the
whereby
page 10.
His prayer
for evidence, my lord. Defense evidence. For defense evidence, page 10, my lord.
Page 10. Whereby the defense evidence has been closed. Defense evidence has been closed. The petitioner, the counsel for the opposite party submits that the present case is arising out of a complaint under section 138 NI Act. Meanwhile, the petitioner has already been convicted. Therefore, the interim order against which the petitioner has filed the present
no interim order is there.
1 minute. Interim order against which the petitioner has approached this court becoming infractious. Hence, the present petition is dismissed as infractious. Yes.
My lords, item number 64, my lords. Item number 64. I have been to VC, my lords.
62.
Item number 64, my lords.
Yes, tell me.
My lords, there is an IA petition on the last occasion, that is on 9th of May 2024, your lordship.
Okay, these matters will be taken up. The leftover matters will be taken up on Monday. Okay.
But there is an interim application, my lords. It is very urgent in nature. We have prayed for a stay of the proceeding before the learned court below. And that petition is still in abeyance.
Monday I am taking up all the matter.
Much obliged, my lords, much obliged.
I'm appearing for the opposite party. I'm appearing for the opposite party.
64, write down so and so entire appearance on behalf of opposite party and files for Kalaknama. The same is taken on record. Leaves the matter. Huh?
May I pray for Tuesday, Your Lordship? May I pray for Tuesday?
There is an interim application, my lord. There is an interim, and today they have filed. They are filing the binama.
Tuesday, yes.
61 already 164 statement में आसिले क्वेश्चन करिए बोली कहितले लास्टली से एफिडेविट होगी पैसा दिया निया हे जाइथिला सब खाली 164 स्टेटमेंट विक्टिम रो आसी जाइछ ऑलरेडी खाली से देखि कि कोइ मंडे
Lordship, the last item.
Yes.
Item number 65.
Yes, sir.
The vigilance case, my lord. Shall I pray, can this matter be taken up if your lordship will be after 9th, after 7th, my lord?
Keep it up, sir.
Any particular date?
He will give it.
Great. Nothing concerned.
Notice answered, awaiting notice, adjourn. And 65 SR is requesting after 17th. Any day. The board is adjusted. I was.